Tes 1, 2, 3. Oke ya, masuk ya. Berdengung nggak? Udah tes ya. Bunyi kayaknya. Pakai aja deh, Mas.
Good morning, distinguished guests, ladies and gentlemen. A very warm welcome to the workshop for labor inspectors on violence and harassment in the workplace. My name is Fitri, and I am delighted to be your host during this event. I would like to acknowledge the presence of all ASEAN member states and ASEAN partner representative participating in this meeting today. Your presence today should develop a positive contribution for labor inspector and sharing information about violence and harassment at the workplace. Distinguished participants, ladies and gentlemen, kindly allow me to invite Honorable Mrs. Hayani Rumondang, the Director General for Labor Inspection and OSH Development, Ministry of Manpower of the Republic of Indonesia, to deliver welcome remarks. Honorable Mrs. Hayani Rumondang, you may have the floor, please.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, salam sejahtera bagi kita semua. Salam, Om Swastiastu, Namo Buddhaya, salam kebajikan dan salam sehat. Distinguished Honorable Asian Labor Ministers Meeting Chair, Minister of Manpower, Republic of Indonesia, Her Excellency Madam Ida Fauzia, Deputy Director General Occupational Safety and Health, Department of OSH, Ministry of Human Resource Malaysia, as the Asian OSNet Chair, Asian Labor Inspector Focal Point, Asian OSNet Member State, representative from International Association on Labor Inspection, colleagues from Japan, Korea, and Australia, ILO experts and ILO colleagues, ASEAN OSNet Secretariat, ASEAN Secretariat, and all participants. First of all, let us extend the gratitude to God Almighty for His abundance of blessing and grace. We are still given safety and health to attend workshop for a labor inspector on violence and harassment at workplace. Distinguished participants, violence and harassment are a series of unacceptable behaviors and practices that aim or result in physical, psychological, and even economic harm and deprivations of workers' dignity. Violence and harassment can create an unsafe work environment for both workers and even have an impact on company performance due to the loss of public trust and deteriorations of the employer's relations with both workers and international buyers. Discrimination interacts with psychological risk and has an impact on violence and harassment in the world of work, safe and healthy work environment free from violence and harassment, the report at a glance, ILO 20 and 20. Victims of violence and harassment are not only dominated by women, even though there are not many men, they are often the object of violence and harassment. With the increasing awareness of the impact of violence and harassment, there have been many prevention and treatment efforts being carried out around the world. Most countries have some form of legislations stipulating that employers have an obligation to ensure and protect the health and safety of their workers and workplace. In a number of countries, these obligations implicitly includes both physical and psychological health. This is also stated in safe and healthy working environment free from violence and harassment, ILO 20 and 20. From these efforts, there are hope that not only how victims are willing and able to convey the violence and abuse they experience, but also how we can take proactive steps to overcome this. Distinguished participants, nowadays, violence and harassment in the workplace is a widespread phenomenon and occurs in many sectors of the world. There are working situations common to a number of occupations that tend to increase the risk of violence and harassment at work, especially in relation to third parties. This includes working alone, working in contact with the public, working with people in distress, working with valuables and cash handling, and work in isolated or remote locations at evening and or night. This is include in safe and healthy working environments free from violence and harassment, ILO 20 and 20. In responding to this challenge, the ILO has issued an instrument related to the handling of violence and harassment in the workplace, namely ILO Convention number 190 on the elimination of violence and harassment in the workplace, supplemented by recommendation number 206 on violence and harassment. In the Asian context, violence and harassment in the workplace has been included in the project under the Asian OSNet Work Plan 20 and 21 to 20 and 25, and is one of the programs to support the chairmanship of the Indonesian Minister of Manpower at the Asian Labor Ministerial Meeting. Distinguished participants, in this regard, it is very important to hold a workshop for labor inspector on violence and harassment at workplace as a forum to share experience and best practices in ending with violence and harassment in the workplace. For these reasons, it is hoped that each Asian member country can provide views, information, and experience on how to manage these issues. Finally, I would like to thank all related parties who have contributed to organizations of this event. I hope that all participants can get optimal benefits from these activities, and I wish you a fruitful and great discussions. Thank you. Wallahul muwaffiq ila aqwamit thoriq. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Madam. Next, I would like to invite Deputy DG Occupational Health Department of OSH, Ministry of Human Resources Malaysia, to deliver the remarks. Honorable Mr. Muhammad Hatta bin Zakaria, you may have the floor, please.
Okay. Bismillahirrahmanirrahim. Thank you, Madam Chairman, Chairperson, the Honorable Director General of Labour Inspection and Occupational Safety and Health Department, Ministry of Manpower of Indonesia, Mrs. Haryani Pemandang, the Honorable ASEAN Labour Minister Chairperson, Ministry of Manpower of Indonesia, Her Excellency Madam Ida Fauziah, ASEAN Labour Inspector Focal Point, ASEAN OSNET member states, representative from International Association of Labour Inspection, ILI, colleagues from Australia, Japan and Korea, ILO experts and ILO colleagues, ASEAN OSNET Secretariat, ASEAN Secretariat, distinguished participants. Assalamualaikum warahmatullahi wabarakatuh dan selamat pagi. It is my great pleasure to welcome you to the workshop for Labour Inspector on Violence and Harassment at Workplace, hosted by Ministry of Manpower of Indonesia. I am sure that all of us here can agree that work should not damage people's health and endanger their safety. On average, we are spending about 8 to 9 hours a day and 5 days per week in the workplace. Therefore, our workplace should be a safe place for us. Violence and harassment can be defined as a range of unacceptable behavior and practices that aim at result in or are likely to result in physical, psychological, sexual, or economic harm. This potentially covers physical abuse, verbal abuse, bullying and mobbing, sexual harassment, threats, and stalking, among other things. According to ILO, women may face a higher risk at workplace-related violence and harassment to men. In particular, a certain group of women tend to be more vulnerable to sexual violence and harassment. Notably, girls and young women, domestic workers, women in a limited job security, migrant women, and women in a male-dominated occupation, and more generally, in situations where a large number of women are supervised by a small number of men. Allow me to share with you a case that happened last April in Malaysia. A cook died after his roommate, who was a former colleague, allegedly attacked him at home with 2 others as they accused him of workplace bullying. This is an example of how workplace harassment or bullying can be elevated to such unfortunate event. In many cases, the co-workers felt that their words and jokes are harmless, but to the victim, they felt harassed by that. We never know how long they suppress their feeling before it erupts and worse, retaliates by violence to the others. Ladies and gentlemen, safe and healthy working environment free from violence and harassment reports published by ILO in 2020 highlighted the challenges to determine with certainty the trend regarding violence and harassment at the workplace. However, there were a number of studies and surveys have been conducted in various countries over the years that show an increasing trend of reported cases, violence, and harassment at the workplace. Something must be done to stop this trend for good, as the violence and harassment at work are not just hurting the targets, but also his or her colleague, family members, and friends. In Malaysia, we have several initiatives done by Ministry of Human Resources to prevent violence in the workplace. First, the Department of Occupational Safety and Health published guidance for prevention of stress and violence at the workplace in 2001. This guideline was developed in collaboration with the United Nations Development Program through a project entitled Occupational Safety and Health Institutional Capacity Building to offer integrated workplace response in managing and stress and violence at the workplace. Secondly, in 2012, the Department of Labor Peninsula Malaysia introduced a specific section in Employment Act 1955, which addresses the issue of sexual harassment. Prior to that, the Code of Practice on the Prevention and Eradication of Sexual Harassment at Workplace 1999 is used as reference. Even though the number of reported cases is relatively low in comparison to the Malaysian workforce, Employment Act 1995 provides legal provision for reporting system on violence and harassment. For serious case involving violence, the employees can report to the police. Today's workshop can be considered as one of the key initiatives under the ASEAN OSNET Work Plan 2021 to 2025 for ASEAN countries to share our insights, information, and knowledge on how to deal with violence and harassment. I believe that we can end the violence and harassment at the workplace and making ASEAN workplace free from violence and harassment, and shows how the right can be realized. The outcome of this workshop can be turned into concrete and practical action. I wish everyone a more fruitful workshop, and I hope the objective of this workshop will be achieved to create a safe, healthy, and harmonious workplace in ASEAN. I reminded of a saying from Prophet Muhammad, peace be upon him, that seemed up to our workshop today. Do not cause harm or return harm. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Distinguished participants, ladies and gentlemen, on this note, I would like to call on the Minister of Manpower, the ASEAN Labor Minister Meeting Chair, to deliver remarks. Her Excellency, the floor is yours.
Honorable ASEAN OSNET Chair, ASEAN OSNET Focal Points, ASEAN Labor Inspection Focal Points, representative of Asian partners, Korea and Japan, representative of International Labor Organization, representative of International Association of Labor Inspection, Asian Secretariats, distinguished participants, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Good morning from Jakarta. First of all, I wish to express my appreciation to all of you who are attending the workshop for labor inspection on violence and harassment at workplace held on 23 November 2021 virtually from Jakarta. I am pleased to warmly welcome you all, and I hope you are in healthy and safe condition today. As the chair of the Asian Labor Minister meeting, I am excited that the Ministry of Manpower of the Republic of Indonesia could carry out this workshop today as part of the ASEAN OSNET work plan in the 2021 until 2025. This workshop will share information, insight, and experiences in protecting workers from violence and harassment at the workplace in Asian region. Distinguished participants, ladies and gentlemen, as we all know that violence and harassment in the world of work is a part of human rights violation. It is a threat to the dignity, security, health, and well-being of everyone involved. In this matter, abuses of human rights have an impact on employees and employers, their families, communities, economies, and society as a whole. Violence and harassment occur in almost all sectors of the world of work, such as the health sector, transportation, education, government, housework, working at night, and remote places. For the fishing sector, therefore all stakeholders in ASEAN must have a strong commitment to create a work environment that is free from all form of violence and harassment. Violence and harassment are also not in line with decent work, and in ILO Convention number 190 and ILO Recommendation number 206, the term violence and harassment is defined as a range of unacceptable behaviors and practices that result in or may cause physical, psychological, intimidation, or economic harm. Distinguished participants, ladies and gentlemen, regarding this matter, I do hope all ASEAN labor inspectors and competent authorities will cooperate and collaborate in taking measures and initiatives to eliminate violence and harassment in the world of work. Those measures and initiatives should be integrated into occupational safety and health laws, policies, strategies, and programs. In addition, some key practices should be undertaken in facing the issue of violence and harassment at the workplace, such as a policy, hazard identification, risk assessment, prevention and control, training, management, and mitigation of the impact, care and support of workers affected, monitoring and evaluation. I believe we all together in Asian region will fight to protect Asian workers from all form of violence and harassment, which is in accordance with the principles of human rights and decent works. I also encourage all Asian labor inspectors and related subsidiary bodies to take action through strong coordination and integration across sectors in law enforcement against the practice of violence and harassment at the workplace. On this occasion, I would also like to encourage Asian OSNET to productively and actively support the development of the Asian labor sectors with activities to achieve the objective of the Asian Labor Ministers' Works Program. Lastly, without the further ado, I hope the discussion today will generate various initiatives and concrete programs and action to ensure the elimination of violence and harassment at the workplace in Asia, as well as foster safe and healthy and harmonious workplaces free from violence and harassment. Distinguished ladies and gentlemen, now officially I open this workshop. I wish you have a great and fruitful discussion. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Her Excellency. Ladies and gentlemen, we are going to take a group photo now, and I would like to invite all the panelists and head delegates to turn on the camera and give your best smile. And we will have a 3 times photos. Okay, on my marks, the formal photos. 3, 2, 1, smile. Hold a second, once more. And would you show your thumbs up, please? The thumbs up. Okay, thank you. Thank you all panelists. We have done... Okay, thank you all panelists. We have done our opening session. Thank you for your kind remarks. Hopefully your remarks would deliver motivation and gain great beneficiaries for us. Distinguished delegates, ladies and gentlemen, to start a morning session, we would have ILO and ILE that will share a global framework and tools on the prevention of violence and harassment at the workplace. And I would like to invite the Deputy Director General of Ministry of Labor and Vocational Training, Kingdom of Cambodia, Mr. Peng Thi Teng, as the moderator for the first session. As information, you have 45 minutes, include the Q&A session. Over to you, please.
Thank you, Petri. Very good morning, everyone. I'm sorry, my Wi-Fi connection today is not stable, so I'm also logging in from my phone. My name is Peng Thi Teng. I'm the Deputy Director General of Labor, Ministry of Labor and Vocational Training of the Kingdom of Cambodia. Today, I will be the moderator for the first session on the global framework and tools on the prevention of violence and harassment at work. We're gonna have two presentations. The first one is about the International Labor Standard and the application, which will be presented by Mrs. Aya Matsura, who is the gender specialist, DWT New Delhi ILO. And the second presentation is about the roles of labor inspector to ensure safe and healthy workplace free from violence and harassment, which will be presented by Mr. Martin Campbell, who is the Secretary General Executive of International Association of Labor Inspection. Each presenter will have 15 minutes for presentation, and then will be followed by the Q&A session. To begin with, may I invite Ms. Matsura to give the presentation. Please, Matsura-san, the floor is yours.
Mr. Teng. Assalamu alaikum and good morning, everyone. I'm very pleased to join this important workshop and following the very important opening session where we heard a strong commitment from leadership. I'm very happy to present the overview of ILO Convention 190 on violence and harassment in the world of work. I hope you can see my screen. So, as you may know, in 2019, world leaders have really come to a consensus and adopted a convention as well as recommendation to address violence and harassment in the world of work. So convention is a legally binding international treaty, and recommendation is not legally binding, but it provides kind of guidance in implementing the convention. So Convention 190 is really a milestone because it is the first international labor standard recognizing the right of everyone to a world of work free from violence and harassment, including gender-based violence and harassment. It came into force on 25th June 2021. And so far, it has been ratified by 9 member states. And from Asia, only Fiji has ratified. And I think different countries in Asia are also considering ratification and taking steps, such as raising awareness and also carrying out legal gap analysis. So many also in the opening remarks, we also heard that violence and harassment is still, pervasive and it needs to be addressed. So in terms of the reasons why these instruments came into, adoption, is because violence and harassment threatens equal opportunities and it is unacceptable and incompatible with decent work. It can constitute a human rights violation or abuse. Obviously, it can affect health, dignity, and family and social environment. Also affects the quality of public and private policies, and may prevent persons, particularly women or other from marginalized background, from accessing and remaining and advancing in the labor market. And it is also not good when we promote sustainable enterprises, and it can also have negative impacts on workplace relationships, reputation, and productivity. So what does Convention 190 covers? The overview is this. So the first kind of 3 parts cover kind of language and framework. So talking about definition, and talking about scope, etc. And parts 4 to 7 presents how the issue of violence and harassment in the world of work should be addressed. And in terms of recommendation 206, it provides a kind of additional guidance in relation to part 3 to 7 in addressing violence and harassment. So first article covers definitions. I think definition was also covered in the opening remarks, but it is defined as a range of unacceptable behaviors and practices or threats thereof. So it means it doesn't always have to be unacceptable behaviors, but even threats of unacceptable behavior is also part of definition of violence and harassment. Whether a single occurrence or repeated, and aiming at, resulting in, or likely to result in physical, psychological, sexual, or economic harm. So you can also see here that there could be intent, or there could be also without intent, but it can result in, or likely to result in harm. And it includes gender-based violence and harassment. The convention also provides definition on gender-based violence and harassment, which is violence and harassment directed at persons because of their sex or gender, or disproportionately affecting a particular sex or gender, and it includes sexual harassment. And in terms of violence and harassment, it talks about a range because sometimes one incidents or other could be maybe blurry, talking about, for example, sexual harassment. It could be, verbal abuse. It could be also assault. So in response to the needs to really try to, cover all forms of violence and harassment, it is, the word range is used so that we can try to address, all forms of violence and harassment. Convention 190 also talks about, who should be protected. So it protects all workers and other persons in the world of work, including employees and persons working irrespective of their contract status, and persons in training, including interns and apprentices, workers whose employment has been terminated, volunteers, job seekers, and job applicants, individuals exercising the authority, duties, or responsibility of an employer. Workers whose employment has been terminated, you may wonder, but this is also to ensure that those people who do not have employment contract also has the right to be protected from violence and harassment, and also to seek remedies and redress. And in terms of application of this convention in sectors, so it also applies to all sectors, whether private or public sectors, and also in both formal or informal economy, urban or rural areas. And convention also talks about where and when these conventions should be applicable. So it applies in workplace, including public and private spaces where there are places of work, in places where the worker is paid, takes a break or meal, uses sanitary washing or changing facilities, during work-related trips, travel, training, events, or social activities, through work-related communications, include those through ICT, in employer-provided accommodation, and when commuting to and from work. So from part 4 to 7, how violence and harassment should be addressed is provided. So it provides core principles, is to respect, promote, and realize the right of everyone to a world of work free from violence and harassment. And it talks about the importance of having an approach which is inclusive, integrated, and gender responsive. And it talks about the importance of also considering third parties. And in terms of this inclusive, integrated, gender responsive approach, that should include prohibiting violence and harassment in law, and addressing violence and harassment in relevant policies, including OSH, including non-discrimination, including in migration policies, etc. And having a comprehensive prevention and combating strategies, enforcement and monitoring, and ensuring access to remedies and support for victims, sanctions and guidance, education, training, raising awareness, and also effective means of inspection and investigation, including by labor inspection. Core principle also talks about the important roles that different stakeholders play, governments, employers, and workers, and their respective organizations. So in terms of protection and prevention, it is important to define and prohibit violence and harassment in laws and policies. And he also talks about the importance of role of public authorities in case of informal economy workers. And also identifying sectors or occupations or work arrangements where workers or other persons are more exposed to violence and harassment, so that measures to address those can be taken. Convention also talks about the role of employers to have a policy in the workplace to address violence and harassment as part of their OSH management, and also identify hazards and assess risks, and then to prevent those risks, and to carry out information and training about hazards and risks associated with violence and harassment. In terms of enforcement and remedies, Convention talks about taking appropriate measures to monitor and enforce national laws, and ensure easy access to appropriate and effective remedies, and safe and effective reporting, and dispute resolution mechanisms and procedures. And then also to protect the privacy of individuals involved in confidentiality, and provide for sanctions. It also talks about easy access to support services and ensure protection against victimization, retaliation. And then also it talks about the importance of recognizing the effects of domestic violence so far as practicable to mitigate its negative impact in the world of work. And it is also good to ensure the right of workers to remove from work situations where they have reasonable situation to believe that they may have dangers to protect their safety. And then ensure that labor inspection and other relevant authorities are empowered to deal with violence and harassment, including by issuing orders requiring measures with immediate executory force and others to stop work in cases of imminent danger to life, health, and safety. And recommendation also talks about the importance of gender-responsive training to be provided to labor inspectors, and also the importance of including addressing violence and harassment as a kind of mandate of the national bodies of, for example, labor inspection. The convention also talks about importance of guidance, training, and awareness raising. So in consultation with social partners, violence and harassment in the world of work should be addressed in relevant policies, such as OSH, equality, non-discrimination. And it is important to have resource materials, training materials, other tools, guidelines, so that social partners, key stakeholders, government officials can also address violence and harassment effectively. And important to also take initiative. I think this is also an important initiative to address violence and harassment as part of ASEAN OSHNET program. So that is a very good practice. So I'm about to end my presentation, but just to share that in South Asia, labor inspectors are also starting, with gender responsive training, for example, in Bangladesh, and to raise awareness on C-190. Also in Nepal, Department of Labor is also raising awareness on Convention 190 and discussing how violence and harassment can be integrated into their work. And I understand that in ASEAN, there have been also initiatives to address violence and harassment through labor inspections. So I really look forward to learning from also your experience so that I can share back in South Asia. And lastly, I would like to share that we are really promoting Convention 190 widely. And one of the initiatives is to create C190 champion videos. So I will share the link to this website, so please visit. And I encourage you to also take a video promoting C190 to raise awareness and disseminate information. Thank you very much for your attention.
Thank you, Matsura-san, for sharing with us the international labor standard and the application, particularly the ILO Convention number 190 on the elimination of violence and harassment in the world of work. May I next invite Mr. Campbell to give the presentation on the roles of labor inspector to ensure safe and healthy workplace free from violence and harassment. Mr. Campbell, please, the floor is yours. Thank you.
Thank you very much. And Assalamu alaikum, selamat pagi, and a good afternoon from South Australia. Thank you very much for the invitation to speak today. I thought I would maybe share how we've had some experiences in Australia to implement the ILO conventions and some recent emerging developments from a safety and industrial relations perspective around workplace violence and in particular sexual violence. and share some of the lessons learned of how IALI can actually support regulators, industry and government in aligning to the ILO conventions. So from my perspective, workplace violence is an enormously serious and systemic problem for a lot of countries and a lot of governments who are trying to investigate them. So the OHS profession has moved away from focusing on physically safe workplaces, which is historically where we all used to focus our attention. And we now find ourselves increasingly dealing with complaints of workplace violence, aggression, assault, and sexual violence, all of which is occurring at work. These are emerging OHS risks for us, and it's something that we need to get used to, because at the moment we're very used to dealing with the physical injuries that people present. So I believe over the next 10 years, as the regulator for work health and safety in South Australia, I think that the next 10 years will see a much greater focus on OHS and labour inspectorates dealing with workplace violence, harassment, aggression, and sexual violence. And historically, these have been the domain of other organisations, and mostly the police. But now, as OHS regulators and government departments, we're now finding ourselves more involved in this space. So in Australia, we have 9 health and safety regulators, 1 in each state and territory, and a Commonwealth regulator. And each one is slightly different to the other, but generally we're all focusing in the same place. In 2011, the OHS laws in Australia were regulated to be one model legislation. And whilst not every jurisdiction initially adopted it, now every jurisdiction, with exception of 1, has adopted the model law. And this is a good outcome for victims, because all states and territories are now working to one bit of legislation. But it's fair to say that, in my opinion, when the work health and safety laws were introduced into Australia in 2011, the legislative drafting did not truly consider the breadth and depth of psychological hazards and risks, and how far that we would be coming to investigate these. And I believe at the time of drafting our laws, many of the psychological risks that we're talking about today, and we've heard in the last presentation, weren't well ventilated, but that has now changed. So as workplace violence and sexual assault hazards and risks become more common and start to ventilate, we, as regulators, we're seeing more reports of them. And types of workplace hazards are expanding from bullying and harassment into areas such as workload issues, work design, gender discrimination, and sexual assaults. So many of these are root causes to psychological illness, and they harm our people, but often they have other criminal offences attached with them. And certainly we need to start working very closely and collaboratively with law enforcement agencies, because there is some crossover in these areas. The growing body of research identifying workload and excessive hours that are linked to depression, and work design that is linked to bullying. So what we're finding is in that research is that our workers are being set up to fail because of how work is designed and how work is expected to be carried out. So as a regulator, I can see this shift in how we respond and deal with these breaches to the laws. They present a very different type of investigation for us, and much different to the types of investigations that we have conventionally seen, which is generally a physical injury. And after all, it's much easier to see an unguarded machine or somebody who has had a finger amputated. You can't see psychological injury. So the human and business cost of a psychological injury, and I use psychological in the broadest sense, it includes violence and aggression. The cost of that is huge. Psychological injury generally involves many weeks, if not months, away from the workplace. Severe cases can result in a worker never returning to a workplace, and even in some situations with the most severe consequences such as suicide. And we've seen these sorts of outcomes in Australia due to violence and harassment and psychological risks not being dealt with appropriately. The human cost is immeasurable and will last a lifetime for the worker, their families, and the loved ones that they leave behind. And from a business cost, the compensation that is paid to workers is extensive. And in Australia, the average cost of a compensation claim is well over $100,000. So research has shown that the productivity and cultural benefits to a happy and engaged workforce is present. It really is belief why any senior leader would not create an environment of happiness, engagement, support, and resilience. But many don't, for a number of reasons. So I'd like to share an emerging trend in Australia, which I'm heavily involved with the Sexual Discrimination Commissioner of the federal government. And this is around the emergence of sexual violence and harassment as an emerging safety risk. And this is very, very much embedded in the ILO articles and conventions that we've just heard of. So in 2019, the Federal Sex Discrimination Commissioner in Australia conducted a review of Australian workplaces and produced a national inquiry into sexual harassment in Australian workplaces report. So as a sort of a refresher as to what we mean by sexual discrimination in an Australian context, in its simplest form, sexual harassment is any unwelcome conduct of a sexual nature that reasonably causes the person harassed to be offended, humiliated, or intimidated. And that lines up with what we've just heard from the ILO. And our national inquiry focused on sexual harassment at work in the workplace. So we looked at the nature, the prevalence, and the drivers of sexual harassment and some measures to address and prevent it. And what resulted was the Respect at Work report, which is available on the website of the Sex Discrimination Commissioner. And that 18 months of work surveyed 10,000 Australian workers, 60 public consultations involving over 600 participants, with 460 written submissions. And many of the participants in that inquiry shared the devastating experiences of sexual harassment and violence at their work and the inadequate way employers responded to that. And it was heartbreaking to hear those comments. So the report found some important themes. And one of them was sexual harassment is very common in Australian workplaces. The survey told us that in every industry and every location at every level of Australian workplaces, this was occurring. And that was 1 in 3 Australian workers had experienced some level of sexual harassment in the last 5 years. Now that was increased from 2012 at the last survey. The report also said that the current system places a responsibility on the victim to make a complaint. And what we found is that of the 1 in 3 people who said that they had been subject to sexual harassment, only 17% reported that to the regulator, which is a very low response. The key theme that came out of the research was that sexual harassment happens in every workplace. It's not just for one type of workplace or industry. It was prevalent across 21 defined industry sectors. And finally, sexual harassment has a high cost. The report working with Deloitte estimated that workplace sexual harassment costs the Australian economy $3.8 billion in 2018. So in response, the Sex Discrimination Commission recommended a new framework for workplaces to better prevent and respond to sexual harassment, and we've aligned those with ILO. The framework provides a holistic approach and looks beyond policies, training, and complaint handling procedures. And it is adaptable for all businesses of all sizes across all industries. And it has 7 key focus areas: 4 to prevent sexual harassment and 3 to respond. So to better prevent sexual harassment, we need strong leadership. We need a greater focus on risk assessment in the workplace. We need policies that build an organizational culture of trust and respect. And we need to use workplace education and training to improve the knowledge of workers and business owners and develop a collective understanding of expected workplace behaviors and processes. And all of these are aligned to the ILO Articles and Convention, and something that IALI has been heavily involved in and pushing forward on a global agenda. So in Australia, Safe Work Australia is our national policy body organisation, and I'm a member of that, and I sit on the Safe Work Australia board. And we've been heavily involved in developing guidance documents for workers and employers to help them understand their duties and build compliant practices. So these include a national guidance document for preventing workplace sexual harassment, and also a national guidance document for preventing workplace violence and aggression. And these documents can be found on the Safe Work Australia website and are free. And for us as safety regulators, that's the minimum standard that we expect in the country. And we work with businesses and organisations to help them meet that. So the work of IALI is to promote best practice amongst global OHS and labour inspectorates and share good work, amongst other things. And what we've tried to do in Australia is take the ILO conventions, take the work of IALI, develop national guidance material that meets our law, and push that across the country. So we've implemented processes to address workplace violence, both physical and sexual, and we're leading the way, or IALI is leading the way in supporting the ILO agenda and a range of conventions. IALI is taking a stronger role in developing global OHS regulators to help them build their capability and produce frameworks to address workplace violence. One such manner in which we do this is our international benchmarking of OHS regulation. So at the moment, we are the only organisation who specifically has a process and a framework to help governments and countries develop, implement, or improve a structured response to managing work health and safety and industrial relations. This is a peer review process where the OHS and labour inspection regulators will help provide opportunities for continuous improvement. The review includes examination of your legal framework, inspector powers, the capability and competency of inspectors and people within the organisation, and how you as an inspectorate sets, implements, and assesses organisational strategy. So to conclude, sort of workplace violence is both physical and sexual in nature. Neither is acceptable. As regulators, we're now seeing, particularly in Australia, seeing an increase in these types of complaints, which is something very different to what we have dealt with before, which is generally physical injury in workplaces. So as a regulator, we have to be flexible and we have to be adaptive to receive these complaints, and we need to investigate them properly, thoroughly, and to a very high standard. So there's a strong body of research that results in practical guidance to address these safety risks and to support workers. IALI is proudly supporting the ILO conventions by sharing best practice and helping global regulators prepare for the emerging trend in workplace safety risks. And this includes workplace harassment, violence, discrimination of every sort. So it's critically important that we get our response correct so we can support workers who are suffering these events and hold the wrongdoers accountable for their actions. We also need to educate industry so they can voluntarily comply and do the right thing. And the benchmarking of OHS regulation assessment process is a significant tool where IALI can help regulators do this. Thank you very much. Back to you.
Thank you, Mr. Campbell, for sharing with us the practical and useful experience on roles of labor inspector in Australia to prevent violence and harassment at workplace. I do believe there is a lot more that we need to learn from Australian experience in preventing violence and harassment at the workplace. May I next move to the Q&A session? We still have 14 minutes. So if you wish to make an intervention, please put up the control flag or kindly use the chat function. You are kindly requested to speak only after you have been called upon by the moderator. Thank you. Is there any question or comment on the two presentations just made? May I invite Ms. Atale Sia from Indonesia?
Thank you. Can you hear my voice clearly?
Yes, I can hear it. Thank you.
Okay. My name is Anita. I'm from Indonesia. I have a question for Iyali. For Iyali, what is the strategic technical program that can be implemented by labor inspector to prevent violence and harassment at workplace? Because we know it's not easy to prove or see evidence on violence and harassment at the workplace. Can you?
Thank you very much for that.
Thank you, Mr. Martin.
No, you're correct. It's very difficult to see that activity in the workplace. And I think the strategies that we, certainly in Australia, that we've helped implement with workplaces include an education program so that business owners and workers understand what the law says, understand what's internationally and nationally acceptable behavior. Then we help organizations implement those policies and procedures throughout the business. I also think it's really important that organizations have a culture of reporting where people feel psychologically safe to raise these issues. If people feel frightened of raising them with their employer, then they won't raise them and it'll be hidden. So education is really important. Understanding the law and having clear guidance material of what is acceptable is important. Then as a regulator, we need to help people do the right thing. But we also need a very robust inspector and investigator program so that when people do the wrong thing, that we respond quickly, we do an investigation thoroughly, and we hold people accountable. So another big part of the work that we're undertaking at the moment is how to manage and support victims. And at the moment, the majority of victims for sexual harassment tend to be women, but there's also a lot of men, and there's a lot of people from transgender, from gay, lesbian, transsexual communities who are suffering as well. So when we talk about sexual violence in the workplace, we're in a process of making sure that it covers all genders and all scenarios, and it's not just focusing on women. So I don't think it's an easy answer to say sort of one thing as a strategy. I think it's really important to have a number of strategies that you can use at different times to support different businesses.
Thank you, Mr. Martin, for the explanation.
Thank you.
Is there any more comment or question?
I'll maybe just finish off by saying if anybody does want any other information or any guidance, please feel free to look at the IALI website, the ILO website. There's some great information on there around Violence and Harassment Convention from 2019, or email me directly, and I'm more than happy to help and share any way that I can.
Hello, can you hear me?
Rapida, in my question, please.
Hello, can you hear us?
Yes, I can hear you now.
Hello.
Hello.
Yes,
I can hear you.
Oh, okay. Okay. First one, I would like to thank you so much for the wonderful presentations. But is it the principle that should be studied and applied in the development of the policy on the rule of the labor inspector of each country? So I would like to exchange with you on the challenge to the implementation of the legislation being pushed into practice, in particular ILO conventions. So that's how that we can to start or to do about the laws of the labor inspector to ensure safety and health at the workplace. So that's why, and I want to exchange from the IRE or from the ILO to explain and more for us to learn from the experience. Thank you.
Okay, thank you. I think the benchmarking document that we use and the process that we use to help regulators and countries really does fit your country or your regulator. So there's not an expectation that every country or every regulator has the best system at the start. It's really about a journey of continuous improvement and sharing what other organizations and other countries are doing. So it's really important that there is political and ministerial support for making improvements. Then the first stage is really having an assessment of what you have, where you're already at, and what you would like to see improved. Then IALI will work through the assessment material to help you benchmark where you sit in relation to other countries in your region or globally, and help and give you strategies to improve. And that might be changes to the law, changes to the legal framework, changes to the regulatory practices. It could be changes to inspector training, procedures, guidance material. And I think the true strength of IALI and the benefits that it can bring is that we have over 100 members and very, very well represented from labour and safety regulators from all over the world. So we've got a lot of resources available that we can share, and then really work with you to determine what's best for your regulator in your country. I hope that helps in some way.
Thank you very much for the questions. And I also agree with Mr. Campbell. It is really a long journey of really continuous journey where we need to make continuous improvements. So in terms of really applying Convention 190, it is good to understand where there are gaps in terms of laws and policies in addressing violence and harassment. So looking at, does your national, law or policy, do they address violence and harassment comprehensively? Does it protect all workers, including workers in the informal economy, in rural areas, etc.? So I think in case during this process of assessing the gaps, if gaps are identified, it's good to improve laws and policies or based on consultation with also employers and workers organizations. And then to also continue to raise awareness on unacceptable behaviors. I think this is also in relation to the question from Ibu Anita previously, that then also Mr. Campbell addressed the importance of raising awareness at the workplace, in all workplaces, also among, not only at the office context, but also in the informal economy, among the workers, among also officials who may be dealing with providing public services, etc. Because through research, we also find that, first of all, not many people report it. And for the reason they share that they think it's kind of minor, so they didn't report it. And in research from Nepal, we also heard that colleagues who spot incidents of violence and harassment, they also don't intervene because they think it's minor. So sometimes violence and harassment behaviors are normalized because the people have limited recognition that it is unacceptable behaviors. If we cannot recognize it, we don't address it, and that continues, that situation continues. So it is really important to raise awareness on all forms of violence and harassment so people can recognize it when it happens and address it, or they can intervene to support victims. And in terms of people who face violence and harassment, those many people do not report it, but they tend to also share, in case they share with family members or friends or colleagues. So I think it is also important to create an environment where colleagues are also, have good knowledge about how to deal with it, so they can provide support when these incidents happened. And I think it's also important to assess the current mechanism to investigate. Many people also raise long procedures or expensive process as a reason for not going into formal investigation. So how can we make it effective and gender responsive? That is also an important question to ask when assessing the current system of reporting and investigation in terms of violence and harassment. Thank you very much.
Since it is time, I may end the first session by now. And once again, thank you, Mrs. Aya Masura and Mr. Martin Campbell for the very important presentation. Thank you.
Thank you.
Thank you.
Ladies and gentlemen, we will now have a break for 10 minutes. Please kindly be seated in this Zoom meeting room at 10:25. Thank you. Distinguished delegates, on the second session, we will have a presentation with the theme Integration of Prevention of Violence and Harassment into Occupational Safety and Health Management System from ILO, and follows the country experience from Japan, Korea, and Australia. In this occasion, I would like to invite the moderator, Mr. Alfian Tan, Ministry of Manpower, Singapore. Mr. Tan, you have 1.5 hours, please.
Hi, good morning, everyone. Thank you for the kind introduction. I'm Alvin Tan from the Ministry of Manpower, and I'm honored to be given the opportunity to actually moderate the session today. And as you have heard, session 2 is actually on the integration of prevention of violence and harassment into occupational safety and health management system. So most of us, we are from the ASEAN OSNet community, and we are familiar with traditional occupational safety and health management system and occupational safety and health risks. So OSHMS is basically a set of elements which we use to actually establish the OSH policy and objectives, and which is eventually used to manage the OSH risks in the company, in the workplace. So we have heard in the opening today some of the work that some of the ASEAN countries have actually done. For example, how Malaysia have set up a code of practice in the countries and even incorporate inside their employment legislation, and how they have actually managed violence and harassment at the workplace. And in the last session, session 1, we have also heard from ILE and ILO, who actually provided a broad overview on the legislation aspects. So now in session 2, I have actually 4 speakers with us today, 1 from ILO, and the 3 other guests from Japan, Korea, and Australia. I will first begin with Dr. Yuka Yujita, who is a senior OSH specialist from ILO Bangkok. She will actually provide us with an overview on the laws and practices and what are the countries' experience in terms of integrating the prevention of violence and harassment into the occupational safety and health management system. So each speaker will have about 15 minutes, and thereafter, at the end of 4 speakers, we'll proceed on with the Q&A, where we'll take questions from the audience. So without further ado, I will now hand over the time to Dr. Yuka Yujita, Senior OSH Specialist from the ILO Bangkok. Thank you.
Good morning. Thank you very much, Mr. Tan, for kind introduction. And good morning, everybody. So maybe let me share my screen first. Maybe I to do that. Good. So maybe we don't have much time. It's only 50 minutes for my presentation today. So let me start the very short introduction of this. The given theme to me is the overview of laws and practices. And this is beyond the Asian countries, because today we have a lot of great speakers, and they will share the experience and the current situation in each of the country in Asian countries. So maybe I will talk about a little bit more the global and regional figure on laws and practices. And in the session 1, my colleague Aya Matsura, she shared the international labor standards C190 specific for the violence and harassment at work. And as you may know, when we adopt the new international labor standard, it's not only just one international labor conference. We have to start more than 2 or 3 years before to prepare for the new instrument. For example, we are now working on the new standards on biological hazards, for example. But actually, we started the preparation for C190 3 years ago, before the launch, right? So it was 2016. And the 2017, the office undertook a systematic review of the legal analysis of 80 member states on regulatory framework on the safety and health, the violence harassment at work. And actually that is from all regions, all sub-regions, and the income groups, and actually the 20 Africa, 15 from America, 4 from Arab states, and 15 from ASEAN and the Pacific, and 26 from Europe. And this report is published in 2017, and a little bit old, is maybe almost 4 years before. But as you know, the legal framework doesn't change so quickly. So maybe this is very good to review this report, overview of the laws and practices. And first, I like to speak about the regulatory framework in the global level. And when we see the national regulatory framework on violence and harassment at work, we recognize there's 2 types of regulatory framework. One is the protection, rights and the prohibition of these, the matter, and to protect the workers abused or the exposure to violence harassment at work. And the second component, this is much more our attention, our interest is the prevention, how to prevent violence harassment at work. But actually, we have to do it in the integrated approach, integrated manner. It's not only rights and prohibition, it's not only prevention, it should be back to back, the side and side, and integrated approach is more important. And when we talk about the protection of workers from violence harassment at work, many countries focus on sexual harassment first, right? By the way, the Aya Matsuda touched upon about the gender-based violence, but when we talk about the gender-based violence in world of work, we include not only the sexual harassment, but also we include, the ILO include trafficking or the sex-based the violence harassment, domestic violence, and also some, in some region, for example, in Africa, they have some female genital issue, the tradition. So that kind of issues is also the gender bias, the gender-based violence harassment. But as I said, many countries has a legal framework against the sexual harassment. And for example, the World Bank conducted the research in 2015, and of those 173 countries, 140 countries already have some regulatory framework against the sexual harassment. But this figure is based on our ILO's study, focus on the 80 member states. But you can see many of the countries already have the sexual harassment regulatory framework. And those legal framework is based on, as you can see, most of them is under the criminal law. And some 30% is the discrimination law or labor law. And Oslo is only 10%, right? And then what about the other violence and harassment, the protection of violence and harassment? Yes, again, we have a lot of countries already have almost 40%, 50% of our studies countries has somehow the legal framework. It includes the mobbing, bullying, violence and harassment at work. That is the protection. And then this type of the violence harassment, most of the law is under labor law. Almost 50% is under labor law. And the some is the non-discrimination. And the criminal law is very low. It's only 10% is the criminal law. And regarding the protection of the violence harassment, many countries has focused on the specific group of workers. That is the persons with disabilities and the migrant workers, mainly the Arab states have a lot of legal framework to protect migrant workers, indigenous and tribal people, especially in the South America, Latin America. They have the specific law. And the member of certain classes of the people, perhaps we can hear some example from Asian countries, and also people living with HIV. So those people are protected by law. Then now move on to the protection, the prevention of this kind of violence harassment. And what about the sexual harassment? Many of the countries more or less the prevention in the framework of the OSH management system. I mean, they focus on the hazards and the risks, and deal with this, to prevent the hazards and the risks. That is the approach of many countries. And in fact, regarding the sexual harassment, many countries have more or less the prevention measures. And they require employers to take action. And actually, almost 49, so almost 50 countries out of 80 countries in studies has somehow the obligation for employers to take action against the sexual harassment. And this is the other violence harassment other than sexual harassment. It includes the physical and the psychosocial violence and harassment. But regarding the physical violence, it's really limited countries. Only 4 countries out of 80 countries in studies has the specific legal framework against the physical violence. That include Indonesia and also the Korea. Maybe we can hear in the following session from their experience and the legal framework about this physical violence harassment. And perhaps the Japan, they have the new law against the psychological violence harassment. These studies are conducted in 2017, so maybe the data is a little bit old. Maybe we can hear from the up-to-date information from the delegation from Japan later. And this prevention aspect, many of the legal law legal framework focus on the specific sector, and mainly the healthcare sector, or the public emergency services, or the education sector, because they are very vulnerable. And transport, for example, taxi driver, they are faced on the very high risk of violence harassment at work. And domestic work, the Aya already mentioned that the specific protection for domestic workers, and agriculture, temporary agency work, or the informal economy workers. So many countries have a specific legal framework protection, prevention against the violence harassment towards these sector workers. And now, what is the practice? Not the legal framework. What is the practice? Already the chairperson mentioned many countries have some framework for the OSH management system. And actually, the prevention of violence harassment should be a part of OSH management system. But we are very familiar with the left on side. This is the PDCA cycle. It's the OSH management system. But for the traditional element of the management system, some management system lack the specific element against the violence and harassment. And maybe we have to think about some additional element specific to deal with violence harassment, that is the psychological support or the clear leadership and exercise and recognition, rewarding, workload management, including the long working hours and the work-life balance, psychological protection. We have to add these elements into our OSH management system. And the engagement of social partners is a key. Today, we will talk about the legal framework and OSH management system, but social partners should play important role, especially for the national OSH system. We cannot lack our social partners to develop our improved national OSH system. And the initiative of workers, employers, organization, they have a lot of activities already taken place. The workers' trade union has their own policy and practice against the violence, and also employers' organization, because this is a part of their social responsibility, due diligence. So they are their own initiative. And also, we have some example of the collective agreement, the global framework, regional, or the sectoral enterprise. For example, global framework, there is some union and the industrial, and the Unilever is the big company. They have some framework, collective agreement against violence and harassment, and also sectoral. For example, in the agriculture, we have the banana sector. They have specific framework against the violence harassment. So I stop here, and this is just the global, the overall figure of the legal and the practice. So come back to you, Chair. Thank you very much.
Yes, thank you, Dr. Yuka Yujita, for your comprehensive sharing and providing us with a broad overview on ILO study and how do we actually prevent and protect workers from both violence and harassment. I think it has provided us with a broad overview of the level of practices in various countries. So now it's my pleasure to invite representatives from various countries to share with us what are their up-to-date experience in terms of integrating the prevention of violence and harassment into their national OSH framework on national OSH management system. I will now invite our guest from Japan, Mr. Ishizu Katsumi, who is the director from the Ministry of Health, Labor and Welfare in Japan, to share with us Japan's experience. Right, over to you, please. Thank you.
Thank you. Could you hear me, colleagues?
Yes, we can.
Thank you. Thank you. And Telemakasi Banyak to the Secretariat of ASEAN at Jakarta. Could you please support me to move forward the slides? Thank you. Yes, okay. Colleagues, could you see my slides, policy on prevention of harassment at workplace? Okay. Okay, thank you very much. And then let me start my presentation. Good morning or good afternoon, ladies and gentlemen. This is Ishizu from Labor Ministry of Japan. It's my honor to have the opportunity to explain Japanese policy and experience on harassment at the workplace. Slide 2, please. Next slide, please. Sorry. In Japan, yes, at first, in Japan, there are various kinds of harassment legally restricted. Today, I would like to focus the first one, sexual harassment, and the last one, power harassment. Next slide, please. And dear colleagues, here, let's confirm or reconfirm why harassment at the workplace should be prevented. First, because it is harmful to workers' rights, physical and mental health. Not only physical and mental health, but also harmful to dignity of workers. And second, it is harmful to working environment and productivity of business. So harassment should be prevented. Next slide, please. Then I would like to explain sexual harassment prevention policy in Japan. Next slide, please. This chart, this graph shows the number of sexual harassment cases which are consulted with local labor bureaus. Labor Ministry of Japan has 47 local offices. They are local labor bureaus. The number of sexual harassment cases had increased until 2007. Then the number of sexual harassment cases started to decrease in 2008. What happened? New Act of Preventing Sexual Harassment was implemented in 2007, and it worked. Next slide, please. The Act in 2007 has two kinds of measures against sexual harassment at the workplace. The first measure is to impose on employers an obligation to cope with sexual harassment at the workplace. And the second is ADR, or Dispute Resolution System alternative to judicial court. Next slide, please. Yes, and employer's obligation is composed of three parts. First is to clarify each employer policy of prohibiting sexual harassment at the workplace. And the second is to implement appropriate measures to prevent sexual harassment. And the last is to establish internal system to provide consultation to employees or possible sexual harassment victims. Next slide, please. And the second measure against sexual harassment at the workplace is ADR, Alternative Dispute Resolution System. Employees cannot cost much time and money to resolve the disputes concerning sexual harassment. So alternative dispute resolution system is very important. Next slide, please. In Japan, there are two types of ADR. Sorry. First is guidance by directors of local labor bureaus. As I mentioned before, there are 47 local offices as part of Labor Ministry of Japanese government. And the second type of ADR is conciliation by committees on sexual harassment cases. Each of 47 local labor bureaus has one committee for sexual harassment cases. The committee is composed of 3 labor law experts. Next slide, please. In 2019, Japanese government revised the policy for prevention of sexual harassment at the workplace. The purpose of revision was to improve effectiveness of sexual harassment prevention. Next slide, please. Then let's move on to the second kind of harassment I would like to talk about today. power harassment in Japan. It might sound a little bit strange. I would like to explain the meaning of power harassment later. Anyway, yes, this chart, this graph shows the number of power harassment cases. The number of power harassment has increased until 2020, or possibly until now. Next slide, please. In June 2020, last year, new Act of Preventing Power Harassment was implemented. The new Act against power harassment at the workplace requires employers to take measures to prevent power harassment at the workplace. Next slide, please. Now, you might be wondering what power harassment is, what power harassment means. The word power harassment, which Japanese people use, is defined words or acts that are based on dominant relationship at workplace, which go beyond the necessary and reasonable scope of the job and harm employees' working environment. Next slide, please. Then, what is dominant relationship? Dominant relationship does not mean upper status at the workplace. It can be based on longer experience or more knowledge at a certain workplace. So, not only bosses, not only colleagues with equal status, but also even subordinates can make power harassment. This is the concept of power harassment in Japan. Next slide, please. And Labor Ministry of Japan categorizes 6 kinds of typical power harassment: physical abuse, mental abuse, separation from a human relationship, excessive work demand, insufficient work demand, and violation of privacy of private life. Power harassment is not limited to only these 6 kinds of activities, but this categorization might be useful to raising awareness of people. Next slide, please. The new Act against power harassment at the workplace has the same legal framework as the Act against sexual harassment, employer's obligation, and ADR. Next slide, please. As I mentioned, the number of sexual harassment has been decreasing in Japan since the implementation of the Act against sexual harassment in 2007. Then, is the number of power harassment cases at the workplace going to decrease by the implementation of the new Act against power harassment? I think it depends on everyday efforts of all labor administration officials, and I believe we can do it. Thank you. This is my end of presentation. Thank you very much. Terima kasih banyak.
All right, thank you, Mr. Kazumi. I think it was a very interesting sharing to hear how Japan has actually moved from sexual harassment to power harassment, and how the legislative framework as well as the dispute resolution framework has actually helped to bring the number of cases of sexual harassment down over the years. So we hope that we will see similar improvements in terms of the power harassment cases in Japan. Up next, we have our guest from Korea, Mr. Yong Yuk Kim. He's the Deputy Director from the Ministry of Employment and Labor, and he will share with us Korea's experience. So let us now welcome Mr. Yong, please. Thank you.
Sorry.
Sorry. Director of Occupational Safety and Health Policy Division at Occupational Safety and Health Office. This is my pleasure to give you a presentation of a national policies on workplace violence and harassment. Workplace harassment is now widely recognized as a serious social issue that can no longer be ignored. For example, workplace bullying among nurses. Sorry. Oh. Thank you. Next slide, please. Thank you. Workplace harassment is now widely recognized as a serious social issue that can no longer be ignored. Among nurses, physical violence by a business owner of an IT business and abuse language by an owner family of a conglomerate have started society-wide controversies. Approximately 70% of workers responded that they have experienced workplace harassment in the data from the National Human Rights Commission. Accordingly, the government set goals to develop and implement compliance measures designed to protect workers from workplace harassment and announced a comprehensive measure called Measure to Eradicate Harassment from Workplace, together with all relevant authorities on July 18, 2018. Since the announcement of those measures, special labor inspections were conducted at the business sites reported workplace violence and harassment with social controversy, which helped improving social awareness through conducting surveys for improvement of workplace culture and presenting recommendations for establishing improvement plans. Next slide, please. Efforts were also made persistent legislations concerning workplace harassment. Amendment bills for the Labor Standards Act, Industrial Accident Compensation Insurance Act, and Occupational Safety and Health Act in relation to workplace harassment were passed in the National Assembly on December 27, 2018. The amended Labor Standards Act and Industrial Accident Compensation Insurance Act were enacted on July 16, 2018, and the amended Occupational Safety and Health Act was imposed on January 16, 2020, respectively. The Labor Standards Act defines workplace harassment as any acts causing physical or mental suffering to other employees or deteriorating the work environment beyond the appropriate scope of work by taking advantage of superiority in rank, relationship in the workplace, and attempt to prevent such acts. In cases where such acts occur, the Act stipulates standards for investigations of the employer, imposition of proper measures for attackers and victims, prohibitions on unfair treatment against victims, and a mandatory indication of preventive measures and countermeasures against workplace harassment in employment regulations. Also, the Industrial Accident Compensation Insurance Act includes any disease caused by workplace harassment in the category of occupational disease. And the Occupational Safety and Health Act prescribes the guidance on and support for prevention of workplace harassment as duties of the government to ensure that all matters concerning workplace harassment to be included in and implemented as the occupational safety and health education. On the other hand, it has been difficult to expect employers to take proper measures against workplace harassment if the assault happens to the employer or other workers who are family members of the employer. However, the recently amended Labor Standards Act aims to address such problems as enforced on October 14 of this year. Starting on October 14 of this year, an employer and employer's family member committing workplace harassment can face the imposition of administrative fines not greater than 10 million won, which has afforded more effective measures to prohibit workplace harassment. Next slide, please. For the purpose of strict implementation of these policies prohibiting workplace harassment, these laws enforce the regional employment and labor offices to appoint labor inspectors dedicated to the systematic prohibition of workplace harassment and develop a guideline on the processing of reports on workplace harassment, and laws that enable workers to file complaints against workplace harassment to the regional employment and labor offices. Once a complaint is filed, guidance on improvement will be issued to take necessary measures, including reinvestigating employers, protecting victims, and conducting disciplinary actions against attackers depending on the given matters through investigations on attackers and victims. When the employer fails to follow the guidance on improvement, the workplace concerned will be included in the workplaces subject to supervision, since such workplaces are suspected of a number of violations of labor-related statutes. At the same time, through amending the regulation on duties of labor inspectors, the grounds to execute special labor inspections have been procured against business sites that have social issues on workplace harassment. For business sites with 300 or more full-time employees, guidance was offered to them whether their employment regulations or by law are properly prescribing the measures to prevent and respond to workplace harassment if ever occurred. In 2020, inspection and guidance were provided for 3,309 business sites and public institutions with 300 or more full-time employees with regards to their preventive and responsive policies against workplace harassment under the employment regulations. Supports were offered for self-regulatory preventive activities at business sites through expansion and distribution of preventive and educational contents against workplace harassment. Next slide, please. In addition, a total of 8 consultation centers for workplace harassment have been in operation around the nation since May 2020, after having 2 pilot centers operated between October and December in 2019. In accordance with the Employee Assistance Program, psychological and legal consultation services have been offered for victims of workplace harassment since April 2020, after workplace harassment was included in the 15 consultation categories for supporting workers. Next slide, please. In addition to workplace harassment, institutional strategies have been established to protect the health of workers dealing with customers from customers' verbal abuse. As society has gone through rapid changes from a manufacturer-oriented industrial culture to a service industrial culture, the number of so-called emotional workers who are forced to express their emotion as systemically controlled while hiding their true feelings while serving duties has significantly increased. Under the circumstance, there have been a number of instances that drew society-wide attention, such as an executive of a company assaulting a female flight crew member and a customer forcing a parking attendant to kneel down at a department store. Subsequently, strong demands were made to prevent physical and mental health problems of workers of service industry. On October 18, 2018, The Occupational Safety and Health Act was enforced, starting the employer's obligations to take necessary measures to prevent health problems for customer service workers against the abusive language of customers. Business owners are required to take necessary measures to prevent and protect workers conducting sales or providing services in person or through information network from health problems caused by customers abusing language, violence, and other acts incurring physical, mental distress beyond acceptable scope. Here, the measure requiring business owners to take to prevent health problems for customer service workers are as follows. Business owners are required to post a statement requesting customers to refrain themselves from abusive language use or advice through verbal announcement. They also need to develop a customer service manual, including how to respond to possible issues with customers and provide training programs regarding the details of such manual and prevention of health problems. Moreover, when a customer service worker experiences or is likely to experience work health problem due to customers' abusive language, a business owner has to take any of the following measures necessary for the worker concerned. Business owners' protective measures include temporary suspension or conversion of duties for victims to promptly leave the hazardous site, extension of recess period, support for treatment and consultation concerning health problems caused by verbal abuse, prosecution, billing complaint, and claim for compensation for damages against cars. Failures to take such protective measures or business owner shall face an administrative fine not greater than 10 million won. Moreover, the business owner can be prosecuted if he or she dismisses or acquits a worker that demands the implementation of such measures unfairly. This particular protective measure has expanded its scope from customer service workers to all workers likely exposed to the abusive language of third parties, including customers, starting on October 14 on this year. Next slide, please. Furthermore, as references to all business sites, the guideline of preparation of health production manual for customer service workers, guideline on assessment of emotional labor by customer service workers, and guideline on prevention of job stress from emotional labor have been developed and distributed. In order to solidify the health protection system for customer service workers, health protection consultation services have been offered for over 2,200 business sites with occupations at high risk, such as call centers, where emotional labor is frequently performed since workers are easily exposed to customers' abusive language due to the nature of duties requiring remote communication with customers. Especially, measures for practical improvement were developed for emotional labor environments through the implementation and pilot operation of an automated shut-off system for malicious phone calls to protect the mental health of workers of call centers. Since the implementation of policies, guidelines on health protection for customer service workers have been developed, and manuals were prepared for each occupation types of customer service. There are a total of 11 occupation types, including nurse, kindergarten teacher, social workers, bus drivers, hotel employees, cash register workers and supermarket, flight attendants, call center employees, telemarketers, insurance planners, and golf assistants. Next slide, please. In 2020, the guideline on health protection of customer service workers was also established for 9 occupations requiring door-to-door and face-to-face service, which are easily exposed to customers' abusive language as they visit customers in person. Such occupations include visiting nurses, consultants of mental health welfare centers, home care workers, home visiting educators for multicultural families, care service workers, visiting consultants, gas meters readers, installation or repair technicians, and inspectors of leased products. In addition, statements requesting customers not to use abusive language are posted in workplaces that provide face-to-face service, and audio announcements are provided to customers using remote service. Under consideration of the unique nature of customers' abusive language, where a third party outside of the employer's management scope is on a silent, a campaign promoting a culture to protect emotional laborers is continuously engaged for general customers online and offline. The social awareness of caring for not only the physical but also the mental health of workers has continued to grow. It is because mental health became a significantly ruling stick to determine the quality of labor as well as the quality of life. From such a perspective, there is no doubt that workplace harassment and customers' abusive language are essential risk factors that must be eradicated. Countermeasures implemented by business owners alone can achieve just so much. Therefore, we need to promote a culture practicing nature and considerate behavior from the social aspect of civil rights rather than limiting such risks only to workplace. I will wrap up my presentation. Thanks for listening.
Yeah, thank you, Mr. Kim, for your very comprehensive sharing. I think we have a very good understanding of what Korea has done since 2018 in terms of amending various pieces of legislation, as well as active promotion and imposing fines on workplaces. And I also noted that Korea has also incorporated this in labor inspectors' duties so that they can actually effectively take enforcement actions as well as investigate various cases. And it is also interesting to note how what Korea has actually done in terms of protecting the customer service workers, who are actually very vulnerable at work. And your last point in terms of the workers' mental health is a very salient and important point, especially in times of COVID-19 pandemic. All right, thank you for your sharing. And without further ado, I will now like to invite Ms. Bev Smith, who is from Australia. She will actually provide us with some insights on what Australia has done in the area of preventing violence and harassment in workplaces. Right, over to you, please. Thank you.
Thank you. So thank you for the opportunity to participate in this important event. My name's Bev Smith and I'm the Senior Director of Regulatory Operations in Comcare Australia. So my role in Comcare is to oversee the Work Health and Safety Inspectorate nationally and to ensure that our regulatory practices and our enforcement decisions are risk-based, they're defensible and they're proportionate. And they're directed to achieving compliance with work health and safety obligations under Australian laws and of course to improve work health and safety outcomes. So if I could have the slides come up. So if we move to the next slide. Thank you. So Comcare's purpose, Comcare is a Commonwealth Government agency and its purpose is to promote and enable safe and healthy work in the Commonwealth jurisdiction. The Commonwealth jurisdiction, as Martin alluded to, we have 7 work health and safety regulators in Australia, one for each of the states and one for the Commonwealth, and I work for the Commonwealth regulator. We oversee most of the Commonwealth agencies, and we've also got private sector in our jurisdiction, ranging from transport companies right through to construction to defence services. So it's a really interesting jurisdiction. Comcare oversees the Work Health and Safety Act 2011, and it also oversees the Safety Rehabilitation and Compensation Act. And so really what Comcare is an integrated provider of health. So the Work Health and Safety Act is focused on preventing harm in the workplace. and it is a criminal jurisdiction, so we do prosecute if employers are contravening their duties, and it is quite serious. But we also work at the other end of the spectrum. So once employees are injured, we work with them to actually deal with their compensation and to assist them with an early return to work, because we know that that's the most effective way of reducing harm. So it is an integrated jurisdiction. I obviously work in the work health and safety regulators aspect of the jurisdiction. So if we move on to the next slide. So we've already spoken about, the other presenters have spoken about what is workplace violence and harassment, and it is quite broad. It goes beyond physical violence. One of the things I'd like to point out in the Australian jurisdiction is that harassment is an objective test. So essentially, the test is if a reasonable person, having regard to all the circumstances, would have anticipated the possibility that the person would be offended, humiliated and intimidated. So it's not subjectively the views of the complainant. People can perceive behaviour as being harassing, but in reality, if an objective person looked at it, they would not think that behaviour was so. So it is an objective test. As Martin alluded to, it also includes sexual harassment, which is an emerging issue for work health and safety regulators in Australia. In Australia, we now know that 1 in 3 workers has been sexually harassed in the last 5 years, and we know that only 17% of those actually report that. So that's an issue for the regulators, which I'll talk about later. Regardless of the form it takes, we know that these types of behaviours, so that result in workplace violence and harassment, are more likely to flourish in a psychologically unsafe environment. And this is where incivility is accepted, so very low-level poor behaviour is just accepted. It's in industries where there are power disparities, particularly gender power disparities, where there's insecure work, and where there are poor complaints handling processes, and there's a lack of transparency about the complaints, and there's a lack of transparency and in the accountability for dealing with those complaints. And so we know that's the sort of environment in which this type of behaviour is likely to flourish. So again, we've seen the other presenters talk about the significant impacts of workplace violence and harassment. It can have significant short and long-term impacts, and it can contribute both to physical and mental harm to the person and also anybody who is witnessing that behaviour. It's just not violent incidents. Exposure to lower level but frequent aggression can also have lasting impacts on workers' health. So, example, for workers who regularly experience behaviours such as swearing, yelling, name-calling, racist, sexual or gender comments, may also have serious long-term negative effects on both their mental and physical health. So if we go to the next slide, please. So in Australia, we have quite a number of laws that deal with violence and harassment. We have the work health and safety laws, which we will focus on, I'm focusing on in this presentation. We have discrimination, equal opportunity laws, workplace relations laws, and in fact our Fair Work Commission can actually put in place anti-bullying disorders. If a complainant brings a complaint to them, they can order the bullying stop. We have workers' compensation laws, and we have criminal laws. As I alluded to, the work health and safety jurisdiction in Australia is a criminal jurisdiction, and there have been a number of prosecutions in relation to employers failing to meet their duties in relation to the management of psychological risk. And the fines in this jurisdiction go up to $3 million for a corporation if there is a serious injury or fatality arising out of the contravention. Okay, next slide, please. So in Australia, work health and safety is regulated under work or occupational health and safety laws. These laws make it clear that workplace violence and harassment are psychosocial hazards. When psychosocial hazards and risks at work are not effectively managed, they obviously increase the risk of work-related psychological and physical injuries, incidents and errors. So under our work health and safety laws, employers have a duty to eliminate risk to health and safety of workers and other persons so far as reasonably practicable. And if it's not reasonably practical to eliminate the risks, they must be minimised. This means in Australia that employers must do all they reasonably can to manage the risk of violence and harassment occurring in the workplace. So how do they do this? And this is where the regulator comes in. So the best way to meet your obligations under the Work Health and Safety Act is for an employer to ensure they have a systematic process to manage psychosocial hazards and risks. And most employers use a risk management framework to do this. And this involves, in the first place, identifying the hazards. And we know from research that the factors that are likely to increase the risk of workers being exposed to violence are for workers who are providing care or services to persons who are distressed, affected by alcohol, confused, those industries undertaking enforcement activities, industries handling valuable items, and generally industries that interact with customers and staff are exposed to customer aggression. In relation to harassment and gendered violence, so sexual harassment, as I've stated before, it's likely more to flourish in environments which tolerate incivility and there's lack of transparency and accountability, and where there is industries with low worker diversity and power imbalances across gendered lines. So those are the sort of risk factors that we would be expecting employers to look at to determine if those risks are apparent in their industries, and if they have those risks or identify those risks, then the Work Health and Safety Act requires that they put in place measures to actually reduce those risks as much as they possibly can. So things that we would expect to see in place as a regulator in terms of an employer who is managing these occupational risks are, systems of work, so clear policies and procedures, explaining what workplace violence is, what harassment is, what the expectations of behaviour are. And one of the things that that is coming out of some of the reports is that these policies and procedures should be trauma informed. And so what we're recommending is that employers have a trauma expert review their policies to make sure that they are trauma informed and person centric, because we're talking about people who have actually suffered a trauma and they have unique requirements in terms of how that is dealt with. Another thing that we'd expect employers to do is work on having a psychologically safe work environment. We know that is really important. People are more likely to raise issues and be transparent about issues if they feel psychologically safe to do so. And I'll talk about the People at Work tool later on, which is one way and which is accessible to everybody that can be used to help with that. Obviously, leadership is also the key in terms of, the behaviour you walk past is the behaviour you accept. So really leadership and supervision is very much the key. And implementing accessible confidential reporting and transparent and person-centric trauma-informed responses. So some of the recommendations that have come out of recent reports in Australia is that it is really important that once someone's made a complaint, it's really important to have a trauma-informed response to that complaint to support that person through them and make sure it's person-centric. Okay, next slide, please. So in terms of the regulator, we become aware of harassment. So there, in Australia, there is a legislative requirement to report certain incidents to the regulator under the Work Health and Safety Act. So if the incident, the violence incident, meets that criteria, it will be formally notified to us. Unfortunately, a lot of harassment complaints don't meet that criteria for notification. So we have to look at other ways of informing ourselves around, those risks in our jurisdiction. So we do that through looking at the media, looking at various reports that happen. So we're talking government reports that occur. Complaints that we might get from workers or worker representatives or through unions. We look at claims data, that's really important. So we look at trends in claims and look at where there might be psychosocial risk factors as a mechanism of industry, and then we look to see if there's particular risks in particular industries. So, it is a jurisdiction or an area where we can't just rely on our notification, our formal requirements. As a regulator, we really need to have good intelligence to be able to identify it in the jurisdiction, particularly if we're going to take a preventative approach. So next slide, please. Oh, okay, so we're up to the next slide, sorry, if you can move to the next slide. Okay, so Comcare's actions, once we become aware of it, as a regulator, we can take we can take proactive action. So if we review intelligence and the intelligence shows that we've got a concerning trend in our jurisdiction in relation to violence or harassment risks, then we can take a proactive approach in the sense that what we'll do is we'll design a program which is directed at that particular issue, and that might involve going out and providing training, information and advice to that employer or that industry about what their obligations are. It also might have inspectors going out undertaking inspections at that workplace. So they go out, they talk to workers, they get information, or they require the organisation to give them information about their systems and how they're managing it, and then they'll assess that against the practices we would expect to see in place. So, guidelines, Australian standards, things that objective measures that inspectors use to determine whether an employer is meeting its requirements. We also do reactive intervention. So this is where we actually get a complaint or a concern. Now, this will be someone who is being subjected to harassment or violence in the workplace. In those instances, we will go out and do an inspection into that particular incident. So again, looking at the circumstances of the incident. But our focus is not on determining whether the person was harassed or not, or whether there was any wrongdoing. Our focus is on the system. So if a person was subjected to it, what were the systems? Did the employer have systems in place? Did they do everything they could reasonably do to prevent that incident, that harassment, occupational violence happening? And did they apply that system in this particular circumstance? So was that system applied and did it work as expected? So that would be the focus, not on a finding of whether the person was actually harassed or not. Okay, next slide. So we've covered off on some of this. So what can an inspector do when they go out to workplaces in relation to this? As I said, they can provide information, advice, monitor compliance with the Work Health and Safety Act. So as I said, that is around going out and undertaking inspections at workplaces, consulting with workers, managers, supervisors, looking at the application of systems, requiring organisations to provide us with information, provide us with their policies and procedures so we can objectively assess those. And as I said, we objectively assess them against national guidance, Australian and international standards, and we've also got codes of practices that in Australia in relation to the management of psychological risk and in some of our jurisdictions. And while those codes are not laws, they are things that courts will take into account in determining whether employers met its duties. The other thing that inspectors can do in this jurisdiction is they can actually issue regulatory notices. So a regulatory notice is where an employer, the inspector identifies an employer as contravening the Act. So they've formed a view that the employer is not doing everything they reasonably can to manage the risks. And what they will do is they will make directions and put in place a time frame in which those directions are to be met to bring that employer up to compliance. And if the employer fails to comply with that notice, they can be prosecuted. So that's quite a valuable tool, and we do use that in this space, both in the space of occupational violence and psychological risks. We also, as I said, in very severe cases where there's been quite severe harm arising out of the exposure, so we're talking severe injuries or fatality, and it's in the public interest, we can prosecute, and we do. We have had a number of prosecutions in Australia relating to it, and at the moment Comcare has an investigation underway with the intention of potentially prosecuting for failure to comply with the duties relating to the management of psychological risks. Can we go to the next slide, please? So what are the challenges for regulators? As I said, the issue for us is that the only way formally under the Act we can find out about these types of risk is through notification. As I said earlier, you know, a lot of, the research shows that a lot of workers are very reluctant to make complaints. Most people who experience harassment in the workplace never report it. And they do that because they fear the impact that complaining will have on their reputation, their career prospects and relationships with their employer. And this is well known. As I said, only 17% of workers who are subject to sexual harassment make a complaint in Australia. So it is not a very ideal way of understanding what's happening in the jurisdiction. So it's really important that regulators have a very good understanding of what are the contributing factors, what things actually contribute to an increased risk of this in the industry, and then they go out and use that data to inform more proactive type of interventions rather than waiting for the incident to occur. So in terms of resources, Comcare has a number of resources. I've got them up here. They're all accessible on our webpage, which is publicly available, so any of you can go in and access these. We've got specific guidance on psychosocial risks, sexual harassment, domestic violence. So there's quite a lot of information there. Safe Work Australia also has some very good resources in terms of and these were real game changers when they came out. These are national guides in terms of how to manage psychological risks, and also guides for employers on preventing workplace violence and aggression. And these are all available at the Safe Work Australia website, and I'd encourage you to look at those as well. They're very good, and our inspectors actually use this guidance material to help inform them about what sort of things employers should have in place to manage those risks. The other, sorry, can we just, next slide please. So, sorry, these resources here, so I didn't, these are the ones from Comcare, and if we move to the next slide. And these are the Safe Work Australia resources. So, as I said, very good resources. And if we move to the next slide now. Okay, this is the People at Work tool. So this tool is also available at a website, peopleatwork.gov.au. So again, it is accessible to all the delegates at this convention. This tool is a very valuable resource. It was developed by all of the regulators in Australia, cooperated to develop this tool, and it's an assessment tool that can help workplaces understand and conduct a psychological risk assessment. It's benchmarked and the only validated tool that we have in Australia to do that. In addition to having a validated and benchmarked risk assessment tool for workplaces, it also provides a lot of resources to employees about how to manage the risks they identify through that risk assessment process. So again, I'd encourage you to go and have a look at that website and the People at Work tool. Next slide, please. And I'm happy to take any questions. Thank you.
Yeah, thank you, Ms. Neef. So I thought that was quite an insightful sharing on the regulators' perspectives on how Australia has actually implemented the regulatory framework and how employers should actually take reasonably practicable measures to actually manage the risk of harassment and violence at the workplace. So thank you, Ms. Neef, for your insightful sharing. So it is now time for the Q&A session. So in session 2, we talk about how various countries have actually implemented the framework, namely Japan, Korea, and Australia. And ILO has also provided us with an opening introduction on how the various levels of implementation across the different countries in the world. So I will now invite questions from the floor. But I think the ILO speaker, Dr. Yukita, is actually not available. So I can actually redirect the questions to Ms. Ariga from ILO. Right. So I will now invite questions from audience, please. Thank you. Okay, there's a question on the chat box for Korea on what the Ministry of Employment and Labour do to actually strengthen the inspection to improve the competence of labour inspectors related to cases of violence and harassment. So it's mainly how you actually build the capability of our inspectors to manage this area. I suppose this is quite a new area to some of us. So the question is about how do you actually build the capability of inspectors? Sorry, Mr. Kim, we can't actually hear you.
Sorry. I'm just in charge of cooperation about safety and health. So if you send me an email, then I will research about your question and reply about it.
Yeah, I think Ms. Teta, Mr. Kim is probably from another department, right? So you probably need to consult your colleagues on how the labor inspection competency is being built, right? Is that correct? Sorry, Mr. Kim? Yeah. So earlier on, did you actually respond to say that you would need Ms. Teta to actually send you the email on a question?
Yes.
Okay. I think we'll follow up I think Mr. Kim will actually follow up the question over email. So I think earlier on, during the presentation, I think our delegate from Indonesia also asked our Japanese presenter on what policy approach does the Japanese government take in terms of improving the regulation. And I think the answer was that the key is actually to involve social partners, because I think like what Ms. Smith has actually said earlier is really about understanding the reality on the ground, because I think most people do not report the cases. So it's really up to the social partners to actually surface the concerns to the regulators, so that the actions can actually be taken centrally. Right. Yeah, does anyone have any questions? Yeah, go ahead, please.
Good morning.
Yes, good morning.
Yeah, Shamaipon from our Secretariat Thailand.
Yes.
I have some question and would like to ask all speakers to share. Normally, the law provides for the adoption of preventive and implement measures to address workplace free from violence and harassment. But unfortunately, if there are workers who suffer from violence, bullying, sexual or harassment related work, as a role of labor inspector, how to develop an effective procedure to deal with that cases to ensure the worker shall receive special support, psychological or guidance. Thank you.
Does anyone would like to answer the question? I think, Ms. Smith, will you be able to take the question, please? Thank you.
Sure. Look, I think I've sort of alluded to it in what I was speaking about. The research that's coming out of Australia in terms of a couple of big reports that have been done, particularly into sexual harassment complaints or issues in workplaces and harassment generally, and also issues of post-traumatic stress where workers are actually exposed to stress and then suffer mental, traumatic incidents, is that they should be trauma-informed responses. And so you really should be getting in experts who have expertise in trauma and responding to trauma to help you develop your procedures and processes, or to run their eye over those to make sure that they're fit for purpose, and they will respond appropriately to someone who has been exposed to trauma, who has particular needs. And in terms of inspectors, it's one of the things that we're looking at is how do we develop that expertise in our inspectors to also get that good understanding of the impacts of trauma and how they can effectively respond to and work with complainants who have actually been exposed to trauma in a way that's consistent with those sort of principles.
Thank you. helping to answer the question. So I think it's basically to summarize how you have just responded is about having a specialist knowledge in terms of trauma, as well as improving the process so that we can actually manage the cases as it surfaces. Right, thank you, Ms. Neve. Does our guest speaker from Japan would like to share what is the Japan's experience in terms of developing labor inspectors competency? Sorry, your mic is actually off.
Could you hear me, colleagues?
Yes.
Yes, thank you. And I believe we are we all belong to labor administration offices. So I dare say the most important is budget, money. Yes, money from the finance ministry. And if we have enough money, we can develop human resources of labor inspection officials. But anyway, even without money, we should train our colleagues, labor inspection officials, and develop their knowledge and experience in order to cope with harassment. Thank you.
Yeah, I suppose this is a new area of work compared to a lot of the other traditional occupational safety and health risks. So I guess substantial amount of budget is actually required to invest in this area so that we can build both capability and as well as increased awareness in this area. Yeah, thank you.
Thank you.
Does anyone, any other delegates have any questions for our guest speakers today? Or does any of our guest speakers have anything further to add to the presentation that you have actually shared earlier?
Look, I suppose from our perspective, this is it's not a novel area, but it's an area where there's, it's still not a lot of confidence in terms of managing, particularly the psychosocial risks in workplaces. And so from a regulator's point of view, we're taking a stepped approach in relation to this. We've just set up a specialist team of inspectors who've got specialist skills in managing psychological risks. So we're recruiting from fields like psychology and other professions that have that skill set, and then we're training them in work health and safety laws. And what we're doing is we're taking an approach of education and advice first. So we're trying to upskill the jurisdiction using the bottom of the regulatory triangle, so the information and advice part of the regulatory triangle. And then obviously after a period of time, our expectation will be that as the jurisdiction matures and develops its capacity to actually manage these risks how we would expect them to manage them in line with the guidance that's out there, that's when we would start taking on a more enforcement role where we've got industry who isn't actually complying with their duties. And so from our perspective, because of this sort of the newness of it, we are trying to take a more sort of cooperative approach and educative approach with industry in the first instance.
I think that's very insightful. So it's about taking a more calibrated approach right from the start before you actually move to a more hard kind of approach. Yeah.
Yes.
I think one more participant that raised hand. Okay, could we have our speaker from our delegate from Laos to actually raise his question? Thank you.
Yes. Thank you, Chair. But we would like to ask, and then my colleague, he is a labor inspector, have some other question for the old speaker. Yes, please.
Okay, hello. So I would like to raise a hypothetical question to speakers and also other member states, as a member states, if they have opinions. Say, like it has been stated, victims of harassment, they are usually refrained, or subdued from reporting the incidents. Let's say a third party would like to intervene on their behalf. What would the recommended actions be from your perspective? Is my question clear?
Yeah, we do get that. That's quite a common scenario, and systems should encourage anonymous reporting because we know that people don't report because they're afraid. There's a culture there where they're afraid of retribution if they report. In terms of a regulator, we commonly have health and safety representatives, which are under our legislation. Workers have health and safety representatives that are elected in their workplaces. So we will have them that will come to us on behalf of the worker to raise an issue. We also have unions that come and raise issues with us. If we get those concerns coming through, even if the worker still wants to remain anonymous, we will say to the worker, we will still take that seriously, and clearly, if a worker wants to remain anonymous, we will respect that. But what we'll do then is we'll focus on the systems. So we'll go and have a look at the actual systems of the employer. Because obviously then if we can't look at the implementation in regards to that worker because that would destroy the anonymity. So we will still do that. We still treat it very, very seriously. It just means it's harder for us as a regulator to then look at how those systems were implemented if we can't look at the particulars of a particular case. But it doesn't mean we will not go in and have a look at that employer's systems holistically and make sure that they've got the things in place that they should have in place to manage those risks. Does that make sense and answer your question?
Yes, thank you very much.
Thank you. Yes, go ahead, please. Thank you.
Yes, thanks so much. So, Chairperson, so my name is Yaswariga from ILO. So, on behalf of the ILO, I would like to add some comments on this issue. So, yes, so post management system is a very framework approach. So, this needs also leadership commitment and also risk assessment and also the PDCA cycle. So, harassment is can be solved through this internal process like the PDCA cycle and also risk assessment and also leadership commitment. And let me share that, as Mr. Ishide-san mentioned, so Japan has some guideline or regulation for the harassment that is including the leadership commitment and also internal consultation system in the company. So employers have to obliged to take the establish the internal consultation system in the companies. And also the employer have to take the action, appropriate action and immediate action to the harassment after the cases. This is mandatory in the law of Japan. So that would be very recommendable for member states to consider this situation. And also as the question had mentioned, so care for the victims is very important. I'm very interested in the Korean system, consultation services system. The Korean government has established 5 consultation services focusing on the specific category of the workers. Thank you so much.
Thank you, Ariga from ILO. I suppose we are drawing, we are fast approaching 12 noon and it's time for lunch. If there are actually no further questions, I can actually hand the time over back to the host. I thank Mr. Kasumi, Mr. Kim, as well as Ms. Min for your valuable time in terms of sharing your various countries' experience with the delegates today. Right. Thank you, everyone. I will now hand over the time back to our host.
Thank you. Distinguished delegates, we will have a lunch break for 1.5 hours, and we would greatly appreciate it if you could return to this room at 1:30 p.m. for Indonesian time for the second half of the workshop. Thank you. Distinguished delegates, for the following session, I would like to invite the moderator, Mrs. Diah Sudarto, the National Project Officer, Violence and Harassment at Work, ILO Jakarta, for this session. Mrs. Diah, you have an hour, please.
Thank you. Good afternoon, Excellencies, Head of Delegation, and distinguished delegates. In this third session, we will have presentation from 5 ASEAN countries: Brunei, Cambodia, Indonesia, Laos PDR, and Malaysia. With the theme of ending violence and harassment in ASEAN countries, we are going to hear more about, among others, the national policies, awareness raising activities, reporting system, measure, and psychosocial hazard aspect. In this 60-minute session, each country will present about for 10 minutes each, and then followed by 10 minutes question and answer. Now it's my pleasure to invite the speakers from 5 ASEAN countries. First, we'll start with Brunei Darussalam, Mr. Muhammad Zulfadli bin Suhail. Please, thank you.
Thank you, moderator Ms. Yasu Darto. Can everybody hear me?
Yes, clear.
Okay. Okay, thank you, Ms. Yasudarto. Can I have my slide, please? Okay. Good afternoon to my colleagues from ASEAN countries. First of all, I would like to present about the complaint mechanism that has been done by the Department of Labor, especially from my department, that is Labor Enforcement Division. Okay, next slide, please. Okay.
Langsung ini nggak sih?
We have what? Okay.
Mr. Muhammad Zulfadli, apparently there is a bit disruption in connection for the internet. Maybe you would like to try turn off the video and restart again.
Sorry about the technical errors. Can everybody hear me now? Can I have the slide, please? Okay, thank you.
Now it's more clear. Thank
continue
you.
About continue about my presentation. Under the Acts and Regulation under the Preview of Labor Enforcement Division, that is Employment Order 2009, and anti-trafficking person. I'm afraid to tell you that under this law, it's not we don't cover about the violence and also the harassment at the workplace. However, we don't cover, or we don't ignore if there's any complaint received from the labor department or any medium, so that we can assess it and how to talk about how to for the next action. Can I show you the next slide? The next slide. Okay. This is the complaint mechanism that is done by the labor department. First of all, the awareness to make people aware of our mechanism, our complaint mechanism. We have there's awareness from the media social, from our department website. Department website, we have a column that we call online complaint, and also we have a hotline that is 24 hours to receive complaints, or if there's any question, if there are any inquiries, or if there are any information of an offences, specifically labor offences. And also we also receive emails, and we also do roadshows to workers, to embassies, and also we also do the press release. With all that, we also introduce, we also always introduce to connect us with hotline, and through hotline we can do some online consultation through WhatsApp if there's any questions, or if there's an inquiry. Also, we also use telephone, email, and also face-to-face at the counter. But now we have to make a face-to-face session according to appointment only. Okay, the most important, the most famous one is through our hotline. People or workers, they like to ask us questions and also complain to us through hotline, because that is easy for them using WhatsApp. And sometimes workers don't want to make it anonymous. They want to make it confidential about their complaint. During that consultation at hotline, we can assess whether is it labor related or not. For example, if the complaint is about labor related, yes, we can assess that, where we can help. For example, at the complaints, if there's any labor cases related, for example, salaries, late payment, salary cut, overtime payment claim, return ticket claim, and also termination with a notice, then we can proceed an action through, for example, mediation, compound, prosecution, also cancellation of workers' license. If we found out there's police cases under the penal code, for example, sexual harassment and also violence and also verbal abuse, we, first of all, can advise them to go to the police also. However, we can also ask our colleague, our contact to the police at the police, how to go about the cases. I can deny it. I can deny it. The workers, yes, we almost have received this complaint about the sexual harassment and also verbal abuse. So what we can do is we can advise them to go to the police, or we can help them to reach them where is the suitable department to handle these cases. So yes, it is true that our inspectors, when we check to the workers' place, yes, we don't equip ourselves with these tools or screening about this violence at the workplace and also sexual harassment. However, yes, we sometimes it's true when I see all this presentation, sometimes the workers is afraid, don't want to tell about this, if there's any problem, is there any sexual harassment or violence. But we can deny it if there's any complaint, yes, we cannot ignore. We can help. So for the way forward about this, Labor Department maybe can work out, or maybe can have a dialogue with the police. Because we already received a complaint about sexual harassment and also violence, so we can sit down and talk how to way forward, how to proceed, if there's any mean of communication, so that we can pass the message to them, or we can work together, or if there's any cases. Okay, next slide, please. Okay, maybe that is all from my presentation. Thank you, Ms. Yesudarto.
Yes, thank you, Mr. Muhammad Zulfadli from Brunei, for your presentation about the complaint mechanism in the Department of Labor in Brunei. It's good to note that although currently there are not really policy or regulation about this issue about violence and harassment, but the received complaint, especially through hotline, which is maybe most likely more convenient if there is a case or victim, is there is commitment that you mentioned, that there is no ignorance about that, and the department and the policymaker try to help in engaging with other institutions like the police, and in the future maybe you mentioned also about the possibility of using tools to address this issue. Thank you. Now up next, I am pleased to invite Mr. Naritman, presenter from Cambodia, to share the presentation from your country. Thank you.
Thank you. Dear distinguished participants, my name is Mangalas. I'm the Deputy Director of Labor Inspection Department. Let me share my screen. Yeah. Can you see my screen?
Yes, but it's a bit smaller. Maybe can you please change to slide mode for the bigger? Yes.
Yes.
Yes, great. Thank you.
Yes. First of all, I would like to say thank you for the organizer to let me to do my presentation about the violence and harassment at workplace today. I would like to inform distinguished participants that the government of Cambodia, we are working very hard to take all necessary measures to elimination of the violence and harassment at the workplace. We try our best to comply with all national, international labor standards of the ILOs, and we are held some national policy and legal frameworks addressed to these issues. So I will show you about in my slide presentation about 4 points. The first point is the national policy and legal framework related to violence and harassment at workplace. And the second one is we talk about the awareness raising activity. And the third one, I will talk about the need in preventing violence and harassment at workplace that my ministry is working on. And the last one is about the way forward. So about the national policy, as you see in my slide presentation, we have a regular strategy phase 4. The strategy is focused on strengthening the quality and the effectiveness of the labor inspection, and about the harmonized industrial relation, especially we address to the improve the working condition and safe and healthy at work for the worker. And we also have, especially in the labor and vocational training strategy plan. This is very important because we are currently issue this strategy to make our working condition in the labor field is more improvement, and to ensure that our workers are safe and healthy at the workplace. And this strategy, we also talk about the elimination of the harassment and violence at workplace. And we also have the Decent Work Country Program. This Decent Work Country Program is work closely with ILO, and the priority point in this program is we talk about also about the health, safety and health, and including the sexual harassment at the workplace. In terms of legal framework, we also have talked some law that address to the issues. We also talk about the violence and sexual harassment in our constitution, with our supreme law. And also, we mentioned it in the criminal code, and the law on the prevention of domestic violence and protection of the victim. And for our labor inspector, we refer to the labor law. In its article 172, we mention clearly about the sexual harassment. As you see in my presentation, we mentioned that all forms of sexual harassment is strictly forbidden in our labor law. So we talk about all forms of sexual harassment. So we not accept any minor action. And we refer to the labor international standard. It means that for the labor inspector, we refer to what the definition that the ILO given about the sexual harassment. So the definition is we take into account to take any action. So for this definition, our labor inspector refer to the checklist that we work with BFC, ILO BFC. It means that Better Factory Cambodia. It means that if the monitor of the ILO BFC define for what sexual harassment, so the labor inspector must follow by that definition. And we also had the law on the suppression of human trafficking and sexual exploitation that respect by the government authority, it's the police to have the authority to implement that law. About the activity of our labor agencies, as you see in my presentation, our labor inspector, we work closely with ILO BFC to implement the joint strategy and joint action plan, and to conduct the training. We have conducted many training for recent years, and we conduct to train all labor inspector and all relevant stakeholders in the central and provincial level. We also conduct the workshop on violence and harassment to prioritize the sector. This activity is we conducted before the COVID-19 pandemic, but now we are delayed, and we hope we can do it after the pandemic. The situation is better, and we in this workshop we address to all relevant parties in 4 sectors, as you see in my presentation, such as the textile and footwear sector, construction, and bride, and especially to entertainment service sector. And the worker and the union and all the social partners. And we also established the National Institute of Labor. This National Institute is just established by the sub-degree because we just get approval from our Prime Minister. And we plan to conduct many training to all people in the enterprise, to all people in the enterprise who are in charge with the administrative tasks and human resources, and to the worker representative, such as union leader, soft stewards, and other publics. And we will include the program or the lesson about the sexual harassment in workplace in our program of training, because we think that the worker and all the relevant parties do not understand well about the definition or the concept of the violent and sexual harassment. That's why our labor inspector didn't receive any complaint. Yes, honestly, I can tell that for my career, maybe more than 5 years, I didn't receive any complaint from the worker about the violent and sexual harassment. I maybe it's unbelievable, but I don't know why, but I will find the exact reason why there is no any complaint about the violence and harassment in workplace in Cambodia. So for Cambodia, there's not any specific data about the sexual harassment in our labor inspection system. About the measure in the preventing the violence and harassment in the workplace, now we are working about to reform our labor inspection mechanisms, and we will focus strongly about the capacity building of our labor inspector in the central level and provincial levels. And also we are working to arrangement of inter-ministerial labor inspection. It means that we will work closely with other line ministries, not only Ministry of Labor and Professional Training, but other ministries such as Ministry of Tourism, Ministry of Agriculture, and Ministry of Environment. And especially we want to inspect with the Ministry of Tourism in the entertainment sector. So I think entertainment sector, maybe there are some cases, there are many cases about the sexual harassment, but we will try to inspect the sector, ask the sector, the prioritized sector, yes. And also we are launching of the self-declaration system of labor inspection and labor inspection via automated online system. We are create this system during the COVID-19 pandemic because we cannot conduct our inspection in place face-to-face. So we create the system, and now we are launching, and we hope this system can help us a lot about to receive any complaint or to help the victim about the violence and sexual harassment at the workplace. And for the report system, as I just said, the enterprise or the worker can make a complaint or can inform to our labor inspector about the system. It means that we make a contact person in the enterprise levels, and we make a group in social media such as the Telegram, and we follow up every day, every time about the situation in the factory. So the worker or the representative of the worker can inform about the issue in the factory very fast to the our labor inspector, and labor inspector that can allow our labor inspector to take any action on time to help the victim or to deal with the issue in the factory. And we also, as I said, we don't work alone. We have to work closely with all relevant parties, such as the worker, the employer, the factory owner, the buyer, the union, the government. It means the other ministry and other social partners. to work with, to deal with, to tackle this issue. Especially we are working with BFC, ILO BFC, Better Work Program Cambodia, to eliminate the violence and harassment in the workplace as soon as possible in the country. Yeah. And for my slide presentation, as I mentioned in my slide, Cambodians have a strong commitment to eliminate the violence and harassment at workplace. And we are happy to work closely with the social partner and especially with the ILO. And even some convention we not yet ratified, but I think we will try our best to respect the provision of the convention, and we plan to ratify the convention that just about the convention on the violence and sexual harassment at the workplace. Yes, thank you.
Thank you, Mr. Naritman, for the comprehensive information from Cambodia, including about national policy, detailed legal framework, and awareness raising measurement. It's good to note that in the awareness raising, there are definitely different activities, including labor inspectors training, and then working with better factory in Cambodia, and then in the training also working strategic addressing priority sectors. And at the end, you conclude by the strong commitment from Cambodia, including the plan to ratify Convention 190 about the violence and harassment at the workplace. Thank you. Now it's my pleasure to invite speakers from Indonesia, Mr. Sunardi Manampiar Sinaga. Kindly please, Pak, silakan. Terima kasih.
Thank you, Moderator Ms. Dia Sudarto. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, distinguished participants. My name is Sunardi Manampir Sinaga. I am the Secretary of the Directorate General of Labor Inspection and Occupational Safety and Health Development, Ministry of Manpower, the Republic of Indonesia. I would like to give presentation on ending violence and harassment at workplace in Indonesia. First, I will start with our national policy. National policy in relation to violence and harassment, Indonesia have a number of policies to ensure the protection from violence and harassment. The policy starts from our constitution, where in Article 27, paragraph 2, state that every citizen has the right to work and decent living for humanity, and Article 28, paragraph 2, state that everyone has the right to be free from discriminatory treatment on any basis and has the right to protection against discriminatory treatment. Indonesia has ratified international convention related to this matter, including the CEDAW Convention and ILO Convention number 100 and 111. We also have a series of acts to emphasize the protection on violence and harassment, including act on occupational safety, act on human rights, act on employment, the criminal code, and many relevant acts. In the minister level, there are also some policies that relate with violence harassment, including the guidelines on the prevention of sexual harassment at the workplace. Awareness raising activity on violence and harassment. The activities for awareness raising activity on violence and harassment at the workplace in Indonesia that currently don't are in the past 5 years. Socialization to employers and workers and on the prevention of violence and harassment at the workplace. Capacity building for labor inspector on violence and harassment. Declaration on zero violence and harassment at the workplace in several industrial parks. Violence and harassment case in the workplace. Number of cases that recorded on online information system data for the protection of women and children years 2020, there was 173 cases specific for violence and harassment case at the workplace. It is predicted that the low number of cases is related with the caution from the victims to report the case by reason of fear on losing their job. Another reason is that the experience of getting violence and harassment mostly traumatized to the victim and they afford to talk about it. According to national law, the law enforcement for this case is managed by the national police.
Excuse me,
yes,
Mr. Sunardi. I think accidentally the speaker is unmute. Can you kindly please unmute? Or the host, Panitia.
So I start again.
Okay, now we can hear you clearly. Yeah, everyone else also give a sign, other countries. Yeah, maybe can you kindly please, excuse me, go back one slide before this, maybe to repeat a little bit. Thank you. Or just if it's challenging, continue with this one. So, yeah. Okay.
It is predicted that the low number of cases in related with the caution from the victim to report the case by reason of fear on losing their jobs. Another reason is that the experience of getting violence and harassment mostly traumatized to the victim and they afford to talk about it. According to the national law, the law enforcement for this case is managed by the national police because categorized as criminal act. Labor inspectors could conduct special inspection present of a case and will endorse an inspection note if they found any violation for the labor law that relates to the case. However, the legal enforcement on the violation on violence and harassment will be managed by the police. Preventing violence and harassment case at workplace. Violence and harassment at workplace is a cross-cutting issues that need involvement from all stakeholders, including but not limited to government agencies, Ministry of Manpower, Ministry of Women Empowerment and Children Protection, National Police, Ministry of Social, etc. National Commission on Anti-Violence Against Women, Employers Association, Labor Unions, non-government organization, civil society organization, academics, etc. The government of Indonesia always encourages employers to include policy on violence and harassment prevention and compliance mechanism in the company regulation or collective bargaining agreement, including establish a grievance channel with supporting personnel to solve the problems, remedial action. We also have a regular meeting to discuss protection on women workers with stakeholders that called Gender Network Platform. In this network, there are regular discussions on how to develop better protection for women workers. Psychosocial hazard aspect on preventing violence and harassment at workplace. Indonesia, under Act number 1 year 1970, concerning occupational safety, required one of the work safety is preventing and controlling occupational disease, both physical and psychological, poisoning, infection, and transmission. This means that we ensure protection for workers through prevention programs on psychosocial factor. Indonesia also have Minister of Manpower Decree number 5 year 2018 concerning occupational safety and health on work environment, wherein one of the article clearly state that that implementation on occupational safety and health recruitment, including the measurement and control of work environment, which include psychosocial factors. As for the promotive and preventive action, there are some efforts that have been done, including maintain psychosocial programs at the workplace, and also psychosocial measurement monitoring. Measures in preventing violence and harassment case at the workplace. Ministry of Women Empowerment and Children Protection of Indonesia established Minister Decree number 1 year 2020 concerning protection house for women workers at workplace with aims to ensure the availability of protection house at the workplace, to provide a mechanism or procedure in the provision of protection house at the workplace, and to build better cooperation and coordination in manage of women workers victim with labor problems, discrimination, violence, and human rights violence in workplace. This decree identified actors that needs to involve, including manpower office, labor inspector. The rule of labor inspection. For violence and harassment sins, the law enforcement according to our national law is managed by the national police. Then the rule of labor inspection will be focused on the inspection to ensure the compliance of labor law and also maintain the labor condition within the enterprises. The technical advisory function of labor inspector prioritized to carry out socialization and also assistance on development of programs to prevent violence and harassment at workplace. Labor inspector also carry out accompaniment for enterprises that need it. Labor inspector also conduct evaluation and reporting for all activity that they did. The role of employers. For employers, they should start by having strong commitment in ending violence and harassment at workplace. The Occupational Safety and Health Committee, which are mandatory, must establish in the enterprises, also encourage to have programs that include efforts to prevent violence and harassment at workplace. Occupational Safety and Health Committee also plays important role for education and socialization and violence and harassment to workers. Next, We encourage employers and employees to have an arrangement on violence and harassment at workplace in the company regulation, collective bargaining agreement, or contract letter. And there also must be an evaluation and reporting activity in the enterprise level. The role of workers. For trade unions, we encourage them to include information on violence and harassment in the education and training programs for their members. Trade unions also can play a role to facilitate case resolvement when there are workers that report their case or they found indication on violence. Workers have to prevent all types of harassment by communicating all company policies and on workplace harassment to all workers and by pursuing effective remedial measures. Why forward? For the next step, there are numbers of activity. Currently, there is a discussion in the Parliament on the draft act concerning elimination of sexual harassment. There is a plan to level up the guideline on prevention of sexual harassment at workplace to be a ministerial decree. We also on process to develop on tools for assessment on violence and harassment at workplace. We also in discussion on develop a special online channel for grievance on violence and harassment at workplace. Development of a command center which integrate the labor inspection services within the center. I think that is all that I can convey about ending violence and harassment at workplace in Indonesia. Thank you.
Thank you very much, Mr. Sunardi Manampiar Sinaga, for the detailed information about the lot of activities that has been conducted in Indonesia that can be lesson learned among, and then some of the interesting good point that we can take note is about declaration of zero violence and harassment at several industrial park, and then data online about how many complaint cases, and then not only recording the data of the cases, but also identifying that you mentioned about what happened if why the number of complaint is low because of other things. So this being prepared by more strategic action by the Ministry of Manpower of Indonesia, including the socialization and engagement with social partners, including employers and workers. You mentioned about the graphic and strategy about role of labor inspector, and role of employers, and also role of workers union. It's also good to note that there is protection house for women workers at the workplace in Indonesia. And in that decree, ministerial decree, it's identified that labor inspection is one of the important actors. And the regular gender network platform is also good to note that it can voice more about this issue. And some way forward about the last thing that you explained can also be strengthening again in the future, and maybe can be discussed further in this session. Now, I would like to invite next presenter speaker from Lao PDR, Mr. Petvinkram Potafong. Kindly please, the time is yours. Thank you.
Can you hear me all right?
Hello.
Hello.
Yes.
Yeah, I'll just share my screen and then I'll be.
I. Yeah. Okay. Okay. Một cái gần đấy, cái thì xem. Okay, thank you, moderator Ms. Sudarto. Good afternoon, ladies and gentlemen. First, may I introduce myself. My name is Ms. Violenceand Suksawat, Director of Occupational Safety and Health Divisions, Departments of Labor and Management, Ministry of Labor and Social Welfare, Latvia. It is my great honor to have the opportunity to share information and experience in providing protections for workers and practically in controlling violence and harassment in the workplace. It is a very important and useful topic for ASEAN member countries, especially the role of the labor inspector to ensure safe and health workplace violence and harassment. For my presentation to share information with you first, next slide. The national policy that we have it is a tool and legislation for using implementation to protection and controlling of the occupational safety and health at the workplace, such as the labor law number 43 that it put some article 143 and 144 to have prohibit employers and employees from violating the rights and privacy of one another, especially towards humans in any form. Example, the touch or touchings in appropriate area, some etc. The next is the national policy is we have also the social security law. This is the new for adapt that we have to put some of the victim that the worker have the victim from the violence, something like that, that the security to have to contribute about the area. And then the next that we have the law on the prevention and prohibitions of the violence against women and children. So, and then the new of the regulation of national policy allow as we have an occupational safety and health decree that currently is being promoted to occupational safety and health law, and now we are studying the structure of the law by studying the laws and regulation from ASEAN member country on occupational safety and health. And next, the national policy is that we have a 5 years national plans of actions to prevent and eradicate violence against women and children. So this is also to make sure that the violence and the harassment at the workplace that to happen to do that. This the 5-year plan to have some activity to do for the women and children at the workplace, that we have the ensure that to working condition at the workplace. And next, the second, we have the second 5-year plan of the actions on the eliminations of the worst form of child labor. So, and then next, that we have the National Social Protection Strategy, Vision 20 and Growth 2025. Next. And for the laws of the labor inspection, that the two that we have also the minister decisions on the rule and function of labor inspector number 4277 give labor inspector power handle violence and harassment in the workplace those sanctions and fine. And these decisions also currently being promoted to Prime Minister decree with wider implementation and significance. So this is we want to develop about the regulation for the labor inspection to do about for violence harassment. And the news of the national policy that we just have, we have a agree of the National Tripartite Occupational Safety and Health Committee, central and provincial, to appointed by Prime Minister of Lao PDR. This is the new for us to. This is the tripartite national committee for work together on occupational safety and health. Next to Lao Federation. Okay. The second is that I want to share with you about the awareness lasting activity. For this, the labor inspector play dual roles in both insurance complaints with and also lasting awareness of the labor law. Awareness lasting campaigns by CHO, NGO in partnership with the government organizations. For the reporting system, the step of the reporting system directly with the labor units management and unions representative to the Lao Federation Trade Unions or Lao National Chambers Commerce and Industry, who also provides concepts receiving and forwarding complaints to the appropriate authority. The district labor social welfare officer or provincial labor social welfare department to direct to the labor management departments of labor management. So, and also the labor inspector to nationwide. The next is the prevention focus point networking that we have. So the tripartite organization as the Ministry of Labor and Social Welfare, Lao Federation Unions, and Lao National Shoppers and Commerce Industry. This national tripartite community established and regular meeting held to discuss national policies. It consists of the ministry and tripartite agencies such as Ministry of Labor and Social Welfare, Ministry of Health, Ministry of Industry and Handicap, and etc. The line ministry that we have the stakeholder work together. And also the local administrative authority that we have, the village administrative office and police that we have to work if we have something happen at the workplace, or we have the complaints from the society or from the employers or employee also that we work with these organizations. The next measure in preventing violence and harassment at the workplace. So we think that we must have internal regulations which are approached by labor authority, including sections on workers' protection. Employees receive orientations about the workplace rule and regulation, and how to know about the about the meaning of the violence and harassment. Or sometimes in Lao PDR, we not too clearly about the meaning of the violence and harassment, the limits of how that we know about the limit of implementation about the labor inspector to do when we come to inspect at the workplace or for help the worker to know about this. So that's why we have want you to do this. And also works mostly done in group setting to detect historic incidents. And next is often to these incidents receive strict authoritative response, example with deductions, referrals of the police and dismissal, etc. Regular inspections visit to labor units with past incidents or these of increased risk. For the psychosocial aspects and interventions of the occupational safety and health management system, that now we lack of the deeper understanding of the violence and harassment, difficulty in effectively integrating anti-violence and harassment into work culture. Resolutions measures mostly focus on the short-term fix and sometimes do not tackle lost cost. So for the law PDR, we have established and regulated some of the regulations on the violence and sexual harassment, but it has not yet gone into specific case of the indications of workplace conduct. In addition, implementing measures to prevent labor and control sexual harassment, we have not yet specifically at this issue. So that's why my presentation to share the view about for situation in law PDR for the ending violence and harassment. Thank you so much for your attention.
Thank you so much, Madam Director. First, I would like to apologize for my mistake and overlook in announcing the names to the change of in the list that I received. And then, yeah, it's interesting to know about that presentation from Law PDR mentioning about the several good national policies that has been in place related to these issues, and also including the acts on the protection of women and children. It's interesting to note that there is ministry decree, a decision on the role and function of labor inspector that have power to handle the case through sanction and fine. And this ministerial decree is on the process to be promoted to the Prime Minister decree. And there's also some activities on awareness raising and then collaboration with other social partners to follow up strengthening this issue. Now, I would like to invite the next last speaker. I'm pleased to invite from Malaysia, Madam Aiston Safinas binti Abdul Aziz. The time is yours. Thank you.
Thank you very much, Ms. Sudarto. Can you hear me?
Yes, can hear you. And there's also message from the organizer from Malaysia. The video is a bit backlight. Maybe could you kindly please shift a little bit?
Sorry, come again?
You. Yes, the host, the organizers committee says that the video a little bit backlight. If it's possible, kindly please shift a little bit, if it's possible. Thank you.
Sure, just give me a minute to shift. It's a bit better, but not so good. I'm still glowing, I think.
It's okay. You have a glowing light there. Yeah.
It's a bit better. Sorry about this. Okay, Assalamualaikum and a very good afternoon, everyone. My name is Aisha, as mentioned previously. I'm an officer with the Department of Labour, Peninsular Malaysia. I will try to be as brief as possible. I know everyone's looking forward to a break. I am too. All right, I have heard such excellent presentations from my counterparts from Brunei, Cambodia, Indonesia, Laos. So I'm a bit hesitant myself. I hope my presentation is well received. It's a bit brief compared to others, I think. But it is what it is. All right, can I have the slides, please? Thank you. Right, thank you very much. Right, I will of course be talking on the same theme, which is ending violence and harassment in Asian countries. Next. So in Malaysia, we do have a national policy against violence and harassment in the workplace, focusing specifically on sexual harassment. In 1999, Malaysia had established a code of practice on the prevention and eradication of sexual harassment at the workplace, which is to be used as a guidance against sexual harassment. Now, later on, this code is replaced in 2012 with amendments being made to the Employment Act 1955 under Part 15A of Act 265, whereby a specific section was inserted to address the issue of sexual harassment. Next. Right. So on raising awareness as well preventing violence and harassment at the workplace, what we've done is actually the Department of Labour had conducted a series of lectures and seminars on labour education, as we call it, which is done on a regular basis, which includes the topic of awareness on sexual harassment at the workplace. Now, in the past, the department had also conducted a sexual awareness at the workplace campaign, which was carried out at the state level offices. Next. Now, reports on sexual harassment are actually reported to the Department of Labour at the district office at the district offices, and the data is then registered in the database managed by the department. The Department of Labour Peninsular Malaysia has 12 offices at the state and federal territories level, and we have in fact 40 district offices, which will enable complainants to come and file the cases. Next. Shown here is the data of sexual harassment cases filed in the department for the past 5 years, and with the highest number of cases being filed in 2016 with 26 cases. Next. Right. So measures in preventing violence and harassment at the workplace. Now, the Code of Practice on the Prevention and Eradication of Sexual Harassment at the Workplace, which was previously used only as a guide since it's a code, has actually been replaced by legislation under the Employment Act. Next. We go on to the reporting system on violence and harassment at workplace in Malaysia, of course. Next. Right. So this is all covered under the Employment Act 1955, Act 265. And of course, at the start of the Act, under Section 2, we define sexual harassment to mean any unwanted conduct of a sexual nature, whether verbal, non-verbal, visual, gestural, or physical, directed at a person which is considered as offensive or humiliating, or is a threat to his well-being arising out of and in the course of his employment. Next. Next, we go on to the specific sections which addresses sexual harassment in Malaysia. which is sections 81A until 81G. So under 81A, we have put on the interpretation for the purpose of this part, which says that complaints of sexual harassment means any complaint relating to sexual harassment made by an employee against another employee, by an employee against any employer, or by an employer against an employee. Next. Right. So for the next few slides, we'll be actually, I'm taking excerpts from the actual act. So it's going to be a bit wordy, but basically all the sections are going to talk about the rationale behind the sections is actually to compel employers to act upon and investigate complaints of sexual harassment at the workplace. Right. So what this specific section is section 81B talks about is that upon receiving complaints of sexual harassment, the employer is obliged to inquire into the matter. If he doesn't do so, it will be considered as an offense and is punishable with a fine of up to, not less than 10,000 ringgit, not more than 10,000 ringgit. And if the employer refuses to conduct inquiry, he must inform the complainant in 30 days of the reasons for his refusal to do so. And again, if he fails to inform the complainant in the time specified of the reasons in writing, it's also an offense. Now, the employer, of course, may refuse to conduct an inquiry into complaints of sexual harassment if he feels that the alleged sexual harassment has been investigated and has not been proven, and if the employer thinks that a complaint is frivolous, vexatious, and not done in good faith. Next. Now, if the complainant is not happy with the refusal of the employer to conduct an inquiry, he may refer the matter to the Director General of Labour. Now, the DG, after reviewing the matter, may direct the employer to conduct an inquiry, or if he agrees with the decision of the employer not to conduct an inquiry, he must inform the complainant of the decision, that no further action will be taken. Right? So again, it is an offense if he fails to do so, if he fails to inquire on the matter when directed to do so. Next. All right. Okay. So 81C. Now, what happens when sexual harassment is proven and the harasser is an employee of the same company? Now, the employer, when such a situation happens, he may take such disciplinary actions, which is to dismiss the employee without notice. He may downgrade the employee, or he may impose any lesser form of punishment he deems fit. And where the punishment is suspension without wages, it shall not exceed a period of more than 2 weeks. Next. Right. So if the case of sexual harassment is against a person who is not an employee, sometimes it may be an outside contractor, right? So recommendations can be made that the person is brought before the disciplinary authority to which he is subject to. Right, next. All right, so previously I talked about the situation where the complainant complained of the matter to the employers. And, the employer may or may not investigate the matter. So in this section, complaints of sexual harassment may also be made directly to the Director General, whereby he shall assess the complaint and direct the employer to conduct an inquiry. And the employer must conduct an inquiry when directed to do so and submit a report within 30 days. Now, what happens if the complaint is against the sole proprietor? That happens, right? Maybe, the sole proprietor is the boss. So what can you do in that sort of situation? Here, then, the Director General himself shall conduct the inquiry, and he shall decide if sexual harassment is proven or not, and inform the complainant of his decision as soon as is practicable. Right. Now, the Director General also has the option not to inquire of the complaint if it has been investigated and disproved, or again, if he's of the opinion that the complaint is frivolous, vexatious, and is not done in good faith. And of course, if he refuses to conduct an inquiry on the matter, he shall inform the complainant no later than 30 days of the refusal in writing, stating the reasons, of course. All right. Now, in the case of sole proprietors, next. 81E, I'm going very fast, I know. All right, so next, I think we go on to 81D, 81E, slide 16, I think. Next. Okay. All right. Okay. In the case of sole proprietors, whether sexual harassment is proven, now the complainant may terminate his or her contract of service without notice, but he will still be entitled to wages as if he had given notice of the termination of contract of service, and he will still be entitled to termination benefits and indemnity as provided for under the Employment Act or under his contract of service. Right. Next. All right, so these are the offenses as previously mentioned. Next. Right. So what's interesting about this is that even though the Employment Act is actually meant for workers who earn less than 2,000 ringgit or those doing manual work. However, Section 81G of the Act states that notwithstanding this part 15A, shall extend to every employee employed under a contract of service, irrespective of the wages of the employee. So, you know, the part where they're earning less than 2,000 does not apply. All right, next. Okay, so this is about the psychosocial hazard aspect on preventing violence and harassment at workplace and its integration to the occupational safety and health management system. So guidance for the prevention of stress and violence in the workplace was established on the 16th of October in 2001. And the guidance on the prevention of stress and violence at work has been prepared as a result of collaborative efforts between the Department of Occupational Safety and Health and the United Nations Development Programme through a project entitled Occupational Safety and Health Institution Capacity Building. Now, the guidance on the prevention of stress and violence at work has been prepared to answer questions stated below with the aim to offer an integrated workplace response to the problem. So the questions are, what is the nature of stress and violence at work? Does work stress and violence affect health and well-being, and if so, how? And what can be done to eliminate or reduce these problems? Next. Now, way forward for our department. Now, So the department will continue to educate employers and employees as well as bring awareness on sexual harassment at the workplace through a series of lectures and seminars. It's actually part of the department's program. And every state has its own KPI to achieve on this. So basically, if I'm not mistaken, we aim to have at least 2 seminars every year to educate employers and employees on matters relating to labor, but also focusing on sexual harassment. Now, at the same time, there is a proposed amendment to the Employment Act 1965, which is in the process of being amended at the moment. And among the proposed amendments includes a provision which makes it the responsibility of the employer to place or display notices which prohibit sexual harassment at the workplace. Now, the proposed amendment has not yet been approved by Parliament. It's still in the process of being read, but we hope that it will be passed. I think that's all from my part. I hope I haven't been too fast. I'm actually feeling a bit weird presenting all by myself here. I hope everything's okay, and any questions I'll be happy to answer. And I also have my counterpart from the Department of Occupational Safety and Health as well, my colleague here with me, Puan Siti Mariam, who will be happy to answer any questions as well. Thank you very much.
Thank you very much, Madam Aiston Safinas, for nothing but explaining detail about the Employment Act from Malaysia, which is consists of many different cases, inquiry, complaints of the situation regarding the sexual harassment and violence at the workplace. It was, we already hear insightful sharing and presentation from the 5 countries. Now we run a bit of time. It's supposed to be a time for Q&A session. Maybe we reduce the time for maybe 3 to 5 minutes. If any of the delegates, participants have any query, question to any speaker, please put in the chat or raise your hand in the icon. Thank you. Okay, I see there's no question in the chat. Okay. Okay, from Law PDR, question to Indonesia. What kind of psychosocial program that are in Indonesia? Thank you. Yeah, please, Indonesia, kindly answer the question from Law PDR. Maybe the speakers from Indonesia or the delegates would like to answer on that, or while waiting. Yeah.
Thank you. Thank you, Lau, for the question. The psychosocial factor that present now in Indonesia are promotion and preventive action. Also, measurement of stress at work.
Okay, that's about the explanation from Indonesia. I hope that's clear for our PDR. And then next question is from Vietnam to speakers from Cambodia. As you mentioned in your presentation, one of measure to reform labor mechanism is launching of the self-declaration system of labor inspection. So how does this self-declaration system work, or could you make it in more detail? Thank you. I would like to invite a presenter, speaker from Cambodia, to respond to a question from Vietnam, please.
Yes, thank you for your good question. In Cambodia, we just launched a self-declaration system of labor inspection. It means that all the private enterprise have an obligation to self-declare about their compliance with labor laws and other related regulation. They have obligation to declare, to make a declaration once per year, and after receive a declaration into our system, it means that their declaration will be recorded in labor inspection system. So it can allow our labor inspector to have a document in advance, and then we will conduct our inspection face-to-face in the enterprise. As you know, because of COVID-19 pandemic, we can conduct our inspection as usual. So this system can makes our labor inspection mechanism still be more efficacious, can be control the compliance of the factory during the pandemic. And in fact, because this system is just launching, and we are in the step of testing, and we are trying to find out some issue related to this implementation, and we hope we can learn a lot about this system. In fact, all the private enterprise have maybe 1 more week to make a declaration, because we commence since 1st October, and can be the end from at the end of this month of the November. And if the enterprise did not make the fact declaration by our system, they will be faced to the penalty by our labor inspector. And in that system, we have a checklist that created by our labor inspector, checklist that mentioned about all the related questions that labor inspector will ask when they conduct the inspection face by face. So it means that all the private company will know before we know all the questions that our labor inspector will ask them, so they can complete yes or no, yes or no in the checklist. It means that the checklist they ask about the question Q&A, question about the yes or no, true or false, have or not. It's an easy question. So the private company, they can complete the question first, and then they send to our system. And so our labor inspector can, when they conduct the inspection face by face, so they will download the declaration and they will ask to follow up about the declaration. This system can help our labor inspector to do the report, to collect the data, and to have all the data of the private company in their hand when they conduct the visit in the factory. I think it's easy for them, and our labor inspector cannot do what they want, because everything they do, they will record. It's will be recorded in the system, especially about the report. About the report when they after they conducting the inspection in the factory, they must complete all the report and record it into the system. So there is another team, it means that the analyzer of the report that work in the office, they can control about the activity of our labor inspector.
Thank you, Cambodia,
even,
for the excuse me. Thank you, Cambodia, for the detail and then responding to the good question from Vietnam, and also explaining about the mechanism of, that you presented, and with the example in the factory and the place. Excuse me, because of the considering the time, and we still have a next session of presentation from the other remaining ASEAN countries. Now I would like to close this session, and then our appreciation and big thank you for all, big thanks to all the speakers and presenter, and also the response and active participation. I will hand over the time and floor back to the host. Thank you.
Thank you, Mrs. Dia Sudiarto. Ladies and gentlemen, we will now have a break for 10 minutes. Please kindly be seated in this meeting room at 3.2. Thank you. Distinguished delegates, we come to the last session, and I would like to invite the moderator, Mrs. Mega Irena from ASEC for this session. Ibu Mega, you have an hour, and over to you, please.
Thank you so much. Good afternoon, distinguished delegates, ladies and gentlemen. It's really an honor for ASEAN Secretariat to be invited by Ministry of Manpower of Indonesia to join this workshop and particularly to moderate this session. This is a continuation of the earlier session where in this time slot, we will be hearing from the Philippines, Singapore, Thailand, and Vietnam on their respective national policies, awareness raising activities, reporting systems, and other preventive and response measures in the respective countries. I'm Mega Irena, Head of Labor and Civil Service Division of ASEAN Secretariat. I'll be moderating this session in the next 1 hour. We are a bit behind the schedule, so now it's 3:05. We will end this session by 4 o'clock or 4:05, depending on the discussions. So each speakers will be given 10 minutes. Kindly observe the time slot carefully. And following the presentations, we will be having plenary discussion with all virtual audience. You may post your questions either by raising hand or writing it in the chat box. So we will have the presentation of Dr. Maria Teresita Cucueco from Dole, Philippines, followed by the presentation of Miss Julia Ng from Singapore. Then Ms. Wanlaya Paliyasit from Thailand. Last but not least, Ms. Nguyen Thi Hong Dip from Vietnam. So without further ado, may I invite now Dr. Tess to kindly deliver your presentation.
Thank you.
Dr. Seth, thank you.
Thank you, Ms. Mega. It's been a long time, and it's even if it's
Indeed. You look fresh and young as always.
It's so nice to see you, Mega. I mean, I miss you. We hope we do a physical very soon. Anyway, can I share my screen so that we don't, thank you. So let me share with you, of course, the Philippines experience on this topic, ending violence and harassment in the Philippines. You know, before, I would like to tell you that, of course, violence, all countries, and I don't think it's just the Philippines, we have a zero tolerance for violence. Definitely, in workplace, wherever violence is not tolerated, especially in workplaces, where this actually becomes more criminal, and it's a criminal act if it is a physical violence. But we see, what we know and what we see in workplaces will then be the psychosocial, the bullying, the acts of threats. And we are addressing this. There is the safety and health policies that are already in place. We have the safety and health law. There are the penalties that also addresses this. But what we would like to show you now is a more challenging situation where we are dealing with harassment. And this is what we would like to share with you, because there are new, we also have, it has also evolved in the Philippines. So in 1995, we already had the first Republic Act law, which is the Anti-Sexual Harassment Act. And it was looking at work, education, and training institutions where they would have all these incidents of sexual harassment. Then lately, I think this was 2 years ago, Republic Act, another law, the Safe Spaces Act, was now signed, is now in existence, that addresses the gaps on equality and safety of men and women in the public and private spaces. So it now expands the crime of gender-based sexual harassment in workplaces as well as in other areas, and I will show that to you. So looking at the timeline, yes, we had an early Anti-Sexual Harassment Act in 1995, which was very it was more for workplaces, but now we are, and of course, with the evolving times, we know that harassment can happen in everywhere, in all places, and that is why we had in 2019 this new law, and finally at the moment we are now even doing more of the guidelines, and you see it here on after the IRR, the implementing rules of the law came out, collection, reporting, managing data on sexual and gender-based sexual harassment. So in this slide, you will see that sexual in the earlier law was really work-related. So you see it's just the workplace. But in the new law for harassment, we know that it will exist and continues to exist in streets, in public spaces, online, workplaces, of course, and even in education and training institutions as well. And this gives you why we said it has expanded even the concepts, even the items, the unlawful acts, the effects, the perpetrators, and penalties, because from workplaces, we are now looking at all unlawful acts which can happen in any setting. So it from usually looking at the workplace where demands, requests for sexual favors. In the new law, we are looking at even unwelcome and pervasive conduct, offensive conduct. So these are now defined as unlawful acts. And in the effects, it is very subjective, but you can already complain if you feel that it would affect the dignity of a person and creates an intimidating, hostile, or humiliating environment for the recipient. And in a previous act, where the perpetrator is usually a person of authority, of influence, or moral ascendancy, now it can be anyone, a colleague, a superior, or subordinate. And this is for the workplace, because in any other sectors, it can be, of course, those who have or who did these unlawful acts. And we do have penalties. This is criminal, so you will have prison, you have imprisonment as well as fines. When this law was passed, there were many awareness raising activities. We call it the VOW. It is an annual observation of the campaign to end violence against women. And we also, because of course, when we talk of violence and sexual harassment, the usual victims would be the women, those who are very vulnerable. And we also have the National Women's Month, where we do have all these learning sessions to promote the welfare and safety of the women. But now, of course, because this is both men and women, the Safe Spaces Act, and it is gender-based, we address that awareness raising to all of this gender-based sector. We also have the National Tripartite Feedback e-Forum towards the ratification of ILO Convention 190, the Violent Harassment Convention, and this has raised the level of awareness of the different sectors on the scope and principles of this ILO Convention. So we are now developing guidelines. This is the reporting system, especially for harassment. Of course, it will include other forms of violence, but like I said, if it is physical, it is immediately reportable. It goes to the police. We are acting on this right away. They will be acting on this right away. But if you look at workplace factors that can contribute to harassment, then this is now this reporting system, which would be, and we're developing the guidelines with the collection, reporting, management of data on gender-based sexual harassment and complaints filed with the DOLA, the Department of Labor and Employment, and of course an online system that's being developed for a paperless reporting for this gender-based sexual harassment data. So this is how it's going to be. I mean, this is now happening. This is being created so that this online system reporting can have, it's going to be launched very soon. So you will also have this dashboard after when the online system is brought out, and you have all of these fields that will be accomplished, and you have all of these violations. So there would be, of course, it's more on harassment, but there are also, of course, violent psychosocial violence that is present here, like stalking, sexual actions. So these are forms of the usual violence, sexual violence, which are which we of course have to address as well, and that is why these are all part of the reporting form, and this is part of that online system that is now going to be brought out. So what are our measures in preventing such violence and harassment at work? There will be inspection, and that's why we are, this checklist also, that online system is also going to be used by the inspectors as they will have the complaints for harassment at work. And then there, of course, with this, the guidelines to support workers also in the informal economy, because we know that these are workers that are very vulnerable for gender-based sexual harassment. So the guidelines actually have been developed. The DOLE has also brought out the advisory on how the workers in the informal economy can bring out their complaints on reports, especially for violence and harassment in their place of work. What are our other measures as we look at the psychosocial aspect of violence and harassment? The DOLE has issued in 2020 a department order on the mental health workplace policies and guidelines, and this would contain all of the incidents that can form into the non-physical violence but are violent as well. And these are those that would provide so much stress also on a victim. And the responsibilities of the employer, the responsibilities of the employees, they're all there, as well as the co-employees. And again, there is a zero tolerance for all of these actions in our policies. So we will continue to fulfill our roles and mandates for in our commitment to the international instruments, to our laws and policies. We continue massive advocacy campaigns, and we will continue, of course, with consultative activities, because developing this for the different sectors, violence will not end in formal workplace. In the informal sector, we're starting with this, but we also know that this can happen even in the agriculture, in different sectors, and that is why it is very important that all of this consultation should happen so that we can address all these violence and harassment and be able to see the proper policies and programs to end all of this violence and workplaces in violence and harassment in all the workplaces. So I think that ends my slide, and thank you for inviting the Philippines to share in what we have been doing and what we are doing in ending violence and harassment in the Philippines, and not just only in workplaces. Thank you.
Thank you so much, Dr. Tess. It's really impressive to hear how the legal framework in the Philippines, the genesis, started as early as 1995, and not only covering workplace, but also education and training spaces. And if I understood correctly, you also already started the tripartite consultation in considering ratification of C-190. That is really a positive development. So thank you. Now let's move on to the information sharing by Singapore. May I invite Ms. Julia Ng, please? The microphone is yours.
Thank you. Good afternoon, everyone. My name is Julia, and I come from TAFTEC, the Tripartite Alliance for Fair and Progressive Employment Practices. Okay, I'll be happy to share with you what Singapore is doing to manage workplace harassment. I can't see the slides. Is it being put up?
Would you be operating the slides?
No, can I trouble the host to do so, please?
All right. Anyone from the host? Okay, this is it. Thank you.
Okay, next slide, please. Okay, just to share some of the statistics. So based on the Ministry of Manpower survey in 2018, the most common type of workplace harassment is verbal abuse, with 2.1% of the workforce reporting that they have experienced this. And this is followed by sexual harassment, which is experienced by 0.3%. And we have also stalking, physical violence, and cyberbullying. Next, please. Next slide. Okay, and the most common perpetrators were really the superiors or the colleagues. For verbal abuse, it came mainly from the superiors, and for sexual harassment, it was mainly their colleagues. Next slide, please. And Singapore's approach is the government, together with the tripartite partners, adopt a multi-pronged approach to address workplace harassment. And this multi-pronged approach comprises enforcement and compliance, support mechanisms, public education, and publicity. I'll be elaborating on each of these areas in the next few slides. Next slide. So for enforcement and compliance, we have the Protection from Harassment Act, or POHA, which was enacted in 2014. So this act is about harassment, and it's really, it's not limited to workplace harassment, but of different kinds of harassment, and it can be in the workplace or otherwise. And so POHA, together with Penal Code, enable the government to take action against the harassers. So today, a victim can file a case with the police to seek criminal charge against the harasser under the Penal Code or POHA, or they can also seek civil remedies by filing claims with the state courts. Next, please. So the brief definition of harassment under POHA. So it can be intentional or unintentional, causing harassment, alarm, distress, and it can also include things like stalking. And in terms of remedies, there are civil proceedings, such as filing for protection orders or damages. In terms of criminal sanctions, it can be fines and or imprisonment. And of course, the court will decide on this based on different factors like the severity of the case. Next slide, please. So other than POHA, we have a set of tripartite guidelines on fair employment practices. And under these guidelines, we have a segment on grievance handling. So the guidelines require employers to implement a grievance handling policy, and handling grievance would include workplace harassment cases. So the guideline says that employers must have this policy in place. They must communicate these to all employees so that they are aware of. And then the HR staff and the line managers who would be involved in handling such cases should be trained to manage and investigate the grievances or the harassment cases independently and objectively. And should an employer refuse to heed TAFTEC's advice to address a workplace grievance or workplace harassment case, then the Ministry of Manpower can take action against the employer. Next, please. So TAFTEC's Workplace Harassment Resource and Call Center receive reports on workplace harassment from different channels. It can come from state courts, the police, or it can come from NTUC, that is the National Trades Union Congress, or it can also come from the NGO, like WARE. And of course, the victims themselves can contact us directly to make reports. And between January 2019 and December 2020, it starts from 2019 because that's when TAFTEC set up this particular workplace harassment resource and call center. Okay, between January 2019 and December 2020, we received about 80 workplace harassment reports, and about 1 in 5 related to sexual harassment. Next, please. So whenever TAFEP receive a report on workplace harassment, we look into 3 areas. First of all, whether the company has in place a policy to address workplace harassment, and whether they have looked into the report. So we found that the company has in place a proper policy and that they have properly investigated the case, then no further action will be taken against the employer, but then TAFEP would work with the employer to help the affected employee get closure. And so closure could be in the forms of, say, an apology from the harasser, or requesting for the management to try to make certain adjustments to the work arrangements so that this employee does not need to work in close proximity to with the harasser. So if the company does not have in place a policy, or they did not investigate the case, TAFEP would then require them to do so. If they refuse to heed our advice, then we will escalate the case to the Ministry of Manpower, and then they can investigate and take action, such as curtail the work pass privileges of these companies. Next, please. And moving on to support mechanisms, we have a tripartite advisory on managing workplace harassment. And this is really a practical guide to employers and employees to better prevent and manage workplace harassment. And for example, this advisory gives tips on what kind of core values an employer should have, such as emphasizing mutual respect, people-centeredness, empathy. And it also highlights what are the principles that would make for a good anti-harassment policy. For example, some of the principles would be zero tolerance, leadership commitment, everyone plays a part. So this is really to emphasize that it's not just the role of HR, the role of the management to tackle workplace harassment, but everyone in the company can play an effective role. So even if you're not the victim of harassment, but you're a witness of harassment, you should actually stand up to the harasser as well, or at least make a report to HR for them to look into the case. Other principles include things like focus on prevention and not just like managing the downstream reports, maintaining confidentiality and neutrality when you're doing the investigation, and accountability. So there must be proper records made on the reports, and then providing an update to the employee who has lodged the report. And this advisory also includes things like a sample anti-harassment policy, because we understand that some employers might not have a HR to help them develop policy. So this is really to facilitate and help employers. Next, please. We also have a tripartite standard on grievance handling, which specifies a set of good grievance handling practices that all employers are encouraged to have. And so employers who adopt this tripartite standard on grievance handling, they will be listed on TAFEP's website. So this is like a public commitment to handling workplace grievances and workplace harassment. And so the employees and job seekers from TAFEP's website, they know that these are the employers who have adopted such a standard. Next, please. Okay, moving on to public education, TAFEP work with our tripartite partners like SNAP, which is the Employers Federation, as well as NGUC, the National Trade Union Congress, to hold different kinds of training and make available resources to employers. So, for example, we have clinics, and then we have workshops. Next slide, please. And then the NTUC would also provide resources and help to unionize companies. Okay, next slide. Next, please. So coming to the last bit on publicity, so TAFEP does put in a lot of effort to raise public awareness of workplace harassment and grievance handling. For example, we have videos, and that we work with the human resource magazines to put up our messages. Okay, next slide, please. We have also done things like media interviews and put up editorials in the national papers, and then we adopted some comic style kind of communication to make our messages more readily accessible to the public in general. Next slide. And also, again, more media interviews as well as some statements we have in regard to some of the cases that we have handled. Okay, next, please. Next, please. Okay, so this is my last slide. And recently, we have also launched a campaign, anti-workplace harassment campaign, to raise awareness and encourage victims to come forward. So this campaign carries the tagline, when it crosses the line, call the line, that is called TAFEP, to report the case. And this campaign also aims to educate people on what are the different kinds of harassment. For example, it can be verbal abuse, cyberbullying, stalking. It can also be sexual harassment. And sexual harassment need not necessarily be physical. It can also be verbal. And this campaign, is carried on different platforms like social media. So we have it on our Facebook, Instagram, YouTube, LinkedIn. We did digital banners and put it up on relevant websites. We also have some out-of-home publicity, whereby we produce posters and have this put up at the bus stops. That's the end of my presentation. Thank you.
Thank you very much, Ms. Julia Ng. This is a very useful best practices that you shared. I think the role of TAFEP, if I pronounce the abbreviation correctly, TAFEP.
That's right, that's right.
Yes, the role of TAFEP is very important, very critical. You follow up reported cases, and also if there's any employers refuse, you also become sort of a channel where you report to the Ministry of Manpower for administrative action. So the role of TAFEP is really important. I think this is useful to know. It would be nice if maybe in the chat box or after workshop, we could kindly get a link maybe to the guideline for employers to handle harassment cases in the workplace in Singapore, and also from the Philippines, earlier shared by Dr. Tess, the guideline for reporting of cases. I think this could be really inspiring guiding principles that we could learn from, including ASEAN Secretariat. Thank you.
Sure.
Let me also now invite Ms. Wanlaya Paliyasit from Thailand. You have the floor.
Good afternoon, everyone. Can you hear the voice?
Yes, clearly. Good afternoon.
Assalamualaikum for Muslim there. Okay, let me start the presentation of ending violence and harassment in Thailand. Is the slide ready?
May I ask the organizer? Yes, there it is.
Thank you. Thank you very much. For the first issue of National Policy for Violence and Harassment in the Workplace, we have the National Strategy for Social Cohesion and Equality to create fairness and reduce inequality in all dimensions. It aims expanding social protection to decrease inequality. For the practices, Thailand was designated measures as a practical for preventing violence. Next slide, please. Thank you. We are talking about the national policy. Thailand was designated measure as a practice, as a practical for preventing violence and harassment in the workplace to public sector first, and then encourage these on this practical to our private sector into legal practices. The focal points of matter in preventing violence and harassment is the Minister of Social Development and Human Security, with integrated the Ministry of Labor to improve safe and healthy working environment free from violence and harassment in workplace. Next slide, please. Thank you. The aspects of awareness raising activity on violence and harassment in Thailand. For the world of work, Thailand recognizes the rights of everyone, every gender, no discrimination, to be free from violence and harassment by set out standard and common framework to protect workers' physical and psychological conditions. Violence and harassment can occur with men and women, but women may face a higher risk of work-related violence and harassment. As a project campaign, that Thailand has been joined in order to promote the rights of women on the International Women's Day since 1995. Next slide, please. For reporting system, as the work rule which employers shall conduct the adoption of preventive and corrective measures addressing workplace harassment in case of in the case is informed that the male employee intentionally watches a female employee changing clothes. The management representative take action by providing more clothes, a safe area for changing clothes, and determining measures to prevent such violence and harassment from occurring in their workplace. Next slide, please. For preventing violence and harassment at workplace in Thailand, Thailand has conducted the project to build and develop a network to protect formal labor from many groups of people from various occupations throughout the country. The network duties as below. First, notification of any clue of unfair labor treatment to labor inspector, such as child labor, illegal practice of migrant workers, and human trafficking. Number 2, to disseminate policy or any labor information to members and general people. The network is really important mechanism can be close to the employee and expand labor protection throughout the country. Next slide, please. About measures in preventing violence and harassment at workplace contains of 3 parts. 1, to enforce and encourage employers and employees to comply with the Labor Protection Act and other related law and regulations, to adhere the principle of gender equality. This is a really important measure for the preventing action and enforcement of Labor Protection Act. Number 2, as the provision for preventing violence and harassment at workplace was described in Chapter 1, General Provision under the Labor Protection Act. Section 16, an employer, a chief, a supervisor, or a work inspector shall be prohibited from committing sexual abuse, harassment, or nuisance against an employee if the employers violated must be prosecuted according to the Labor Protection Act. Next slide, please. About the measures in preventing violence and harassment at workplace. The last one, the Minister of Labor has to issue the Thai Labor Standard, TLS 8001, 2020 by is for enterprises to provide social responsibility on their workers, which consists of 2 main parts of requirements: labor management system and labor rights and protection. There are 14 requirements totally. About the preventive violence and harassment at the workplace was appointed at 4.9, sexual harassment and violence. Next slide, please. For reporting system on violence and harassment at workplace, as the establishment provide the work rule and the legal framework, so When the incidents occur in the workplace, the work group will also require employees to report such the incidents that will show that management is committed to dealing with incidents involving violence, harassment, and other unacceptable behavior. Next slide, please. This is true as workers are facing various forms of hazardous work conditions, including emergency risks. To keep workers safe and healthy, occupational safety and health system can be adopted. Occupational safety and health management system can be adopted and implement sets of actions that monitor and evaluate the workplace, and also have an appropriate measures to prevent violence and harassment. For the last slide, Thailand encourage and create opportunity for all workers in various fields like freedom of expression and accepted, create educational opportunities, family stability, self-improvement, justice, gender equality, labor protection mechanism establishment. That's all for the presentation. Thank you very much.
Thank you very much, Ms. Wanlaya. I think this is very interesting how the Labor Act and also labor standard issued by the Ministry of Labor and the policy issued by Ministry of Social Development and Human Security really complement one another and put emphasis on the preventive measures that should be taken by the employers apart from the corrective measures. So this is really a showcase of good coordination and complementary legal framework issued by different ministries. So thank you for that. Last but not least, may I invite Vietnam, Ms. Nguyen Thi Hong Dip, to kindly share your information. Microphone is yours.
Thank you, Ms. Mega. Let me share my screen. Okay. Can you see it clearly? So Vietnam is the last country that sharing information about the topic of the workshop today. So I have many time to revise my presentation and make it different from the one that I sent to the organizer. So I will send it again to the organizer for the material of the workshop. So this is a slide that we update some information about Vietnam, Socialist Republic of Vietnam. Firstly, I would like to share a legal framework on the theme of the workshop. So in Vietnam, we have a labor code. It's the legal document that provides definition and others to the violence and harassment in the workplace, and law on complaints, law on denunciations, law on handling of administrative violence, law on inspection. That kind of laws help inspection the mechanism to do our job and create a mechanism for worker and employer to report to the authority agency to resolve the problem. And criminal code is a legal document that have some criminal regulation. So that is our legal framework. So as you know, in Vietnam before 2019, there was only one article of the Labor Code that regulated sexual harassment, and it's on the Clause 2, Article 8 of the Labor Code 2012, forbidding actions. It provides more treatment of employees' sexual harassment in the workplace, and there are no more elaboration regulation. So labor inspector have no legal basis to do the inspection and sanction violations, and as a result, we have no statistics for that for that team. So in 2019, the Labor Code amended and is effective from the 1st January 2021. And this is the first time the definition of sexual harassment is was made. And there are clause 2 and 3 of Article 8. The forbidden action is including that sexual harassment, and to elaboration this regulation degree number 145/2020 specifically and detailed regulate. So I would like to share some regulation on the labor codes. So the first definition of sexual harassment is regulated on labor code. So sexual harassment in the workplace means any sexual act of a person against another person in the workplace against the letter will. And the workplace means the location when an employee works under agreement or assigned by employer. And this is the clause 2 and 3 of Article 8, forbidden action, maltreatment of employees, forced labor, and sexual harassment in the workplace. And in the degree number 145, there are 3 articles about this sexual harassment. So on Article 84, it's about sexual harassment in the workplace. And it's regulate detail the form of sexual harassment, specific action that recognize and kinds of workplace. And in Article 85, it's about employer regulation on preventing and combating sexual harassment in the workplace. So according to this article, employers must issue an internal labor regulation in which include regulations on preventing and combating sexual harassment. In the internal labor regulations of the employer, the appendix of the labor regulation, they have they have the following primary contents as the first, sexual harassment in the workplace is prohibited. The detailed and specific descriptions of that are considered sexual harassment in the workplace according to the characteristics of the works and the workplace, and responsibility, deadline, and procedures for responding to sexual harassment in the workplace, including those for filing and settling complaints and accusations and relevant regulation, disciplinary actions against perpetrators of sexual harassment and false accusation, which depends on the nature and seriousness of the offense, and compensation for victims and remedies measures. So all that content have to including in the internal labor regulation of the employee, of the company or the enterprises. So which is the responsibility of preventing and responding to sexual harassment in the workplace. So the labor code and its degrees provide that the employer, employees, and the internal employee representative organization have responsibility. So from the day of the labor code 2021 went in force, the employer must amend and supplement the internal labor regulation. So the responsibility of the employer shall the first implement and supervise the implementation of regulations of law on preventing and combating sexual harassment in the workplace. The second, organize dissemination of regulations of law on preventing and combating sexual harassment in the workplace among employees. And the third, prevent or end or respond to sexual harassment in the workplace whenever a complaint or accusation is made. Take measures to protect the privacy, dignity, honor, and safety of the victims, plaintiffs, and defendants. That is a responsibility of the employer. So the employee shall strictly implement regulation on preventing and combating sexual harassment in the workplace, participating in a development of a work environment without sexual harassment, and prevent and report sexual harassment in the workplace. So the responsibility of the internal employee representative organization. The first participate in the formulation, implementation of supervision of the implementation of regulations on preventing and combating sexual harassment in the workplace, provide information and consultancy, and present sexually harassed employee and employees accused of sexual harassment, disseminate and provide training in regulations on preventing and combating sexual harassment in the workplace. Employer and internal employee representative organizations are recommended to select topics of preventing and combating sexual harassment in the workplace to carry out corrective bargaining. So about the responsibility of the DOLISA, the Department of Labor in Violenceand Social Affairs, they have to receive and review the internal labor regulation to ensure compliance with the provision of the labor law. And about us, labor inspector, we have to do our task, that is inspecting the observance of the laws on internal labor regulation and labor discipline and sanctioning the violations. So other responsibility of the government agencies, the Ministry of Labor and Violence and Social Affairs shall take charge and cooperate with relevant authorities in disseminate policies on female employees, gender equality, and preventing and combating sexual harassment in the workplace. And the People's Committee of Provinces shall disseminate and inspect the implementation of policies on female employees, gender equality, and preventing and combating sexual harassment in the workplace. So the legal treatment for committing sexual harassment in the workplace, a person who violates internal labor regulation shall be disciplined. The heaviest form of discipline is dismissal. So that is one kind of legal treatment. And the second is sanctioned. A fine ranging from 15 million to 30 million shall be imposed for sexual harassment at the workplace, and from 50 million to 75 million for sexually harassing the domestic workers. This regulation is only on the draft degree, and it will be issued and approved in December this year. We hope that. And the third legal treatment is criminal responsibility. It is constitutes the crime. If the person who commits sexual harassment is the employer, so the employee has the right to unilaterally terminate the labor contract without prior notice, and they also have the right to report and to complain or denunciate to the authority agency for resolving this problem, following the law on complaint or the law on denunciations. And if the employers coerce or maltreat employees to the extent of not being subject to criminal prosecutions, they will be fined from 50 million to 75 million Vietnam đồng. So the way forward, because this legal regulation is very new, that went in force in the 1st of January 2021. So now we are the labor inspectorate have the legal basic to do our stuff more than that in the past. So we have to providing training for labor inspectors on new regulation of the labor code on violence and harassment in the workplace, and new decree on penalties that will be issued at the end of this year. And we are now submit to the Prime Minister the draft master plan on enhancing capacity for inspector for the period of 2021-2025. We hope that at the end of this year, the Prime Minister will approve this, and we have the chance to improve our capacity for labor inspection, and in which we have the chance to improve our knowledge and skill to detect the violation of violence and sexual harassment at the workplace. So finally, attending this workshop, we hope to learn experiences from the other ASEAN member states, experts from ILO and ILE, and thanks Indonesia for the very useful workshop and fruitful organization. And thank you all for your listening. Thank you.
Thank you, Ms. Hongdip. Congratulations for the enactment of your labor code in January this year. This is really new, and it provides really clear parameters now on the responsibilities of employers, by which employers could be held accountable, and charges for based on the criminal laws, with some sanctions also quite high. And you are planning now for training programs for the labor inspectors to make sure effective enforcement of this new labor code. So congratulations for the impressive progress in Vietnam.
Yeah, thank you, Nina.
Yes, and so we have now about 7-10 minutes for the plenary discussion. Let me open the chat box. There are a couple of questions. One is for all speakers, and the other one is directed to Singapore. I myself have a question, but I'll reserve later. Let me start first with the direct question to Indonesia. Direct question from Indonesia to Singapore. Based on the survey in 2018, Ministry of Manpower of Singapore, there was 2.1% verbal abuse of the workforce, which is quite high compared to sexual harassment, 0.1% stalking, and 0.1% physical violence. How Singapore sort out the complaint mechanisms for these problems, and currently what actions have been taken by law for the positions of verbal abuse. So may we invite Ms. Julia Ng to kindly clarify. And then after that, there is also a question from Ms. Yuka of ILO, addressed to all speakers. Often, violence and harassment incidents are invisible, complicated, and sensitive. Apart from regulatory mechanism managed by the government, what measures are taken to engage experts, medical and social and other stakeholders? Any advice on how to facilitate the coordination and collaboration of all actors? So I will invite later all speakers to respond to this question. Actually, my question is also quite related to this question from ILO. We know that I think many of the cases of harassment are unreported because of the issue of confidentiality, insecurity, to some extent stigmatization. And so we have heard that from all these presentations that in the Philippines, Singapore, Thailand, Vietnam, you have clear legal frameworks, programs, measures, including corrective measures that are in place. And so what is the role of labor inspectors in promoting, more cases to be reported in a way that it promotes awareness among workers to make sure that they will feel less insecure and feel comfortable and protected to report cases. So maybe labor inspectors also play a role in awareness raising in the workplace. And so, okay, let me now first invite Ms. Julia Ng to kindly respond to Indonesia's question.
Okay, thank you for the question. So basically, when we receive a report on harassment, so say in this case you're interested in verbal abuse, we would also advise the this employee to also consider lodging a report to the police, and then leave it to the police to decide whether, based on the facts of the case, whether the police have enough evidence to pursue a criminal investigation against the harasser. So for us, for TAFEP, then what we would do is we would work with the employer. We would tell them, hey, we received this report about verbal abuse happening in the company, but find out from them whether they have heard about this report. If they have, what have they done about it? And then we will get a report from them as to what did he do in terms of investigating into the case, and then we will assess as to whether they have done a proper job investigating the case and what actions were taken against the harasser. So from what we from the different cases that we heard of, for example, we may find that the employer may counsel this harasser, send this harasser for compulsory training to make this person understand that you should respect. In the office, there are ways to be an effective supervisor without having to use abusive language. Sometimes the employer may actually send a warning to the supervisor, and in some of the cases, we've seen that if the employer have given opportunities for this supervisor to improve, maybe with training, with counseling, with warning, and yet this supervisor, maybe he has anger management issues, and he repeats the abuse. Then we have certain cases we have seen that the employer may decide that, okay, in that case I will have to remove you from the supervisory role, and since you cannot, you clearly show that you cannot be a leader, in a sense, a people leader, and so you'll be removed from the job of being a supervisor, and so that yes, reduce the opportunities for him to be a harasser in the workplace.
Thank you. This is impressive that you really cover a wide spectrum of different types of harassment. It is not easy to handle cases such as verbal abuse, for example. It's your words against my words and so on. So it can be quite tricky, actually. I think this may be discussed further in a separate workshop just to go into the details of different kind of cases and handling. Thank you.
Thank you. Maybe I'll just touch briefly on the other question raised by the ILO. So I think it's about, so what can we do with the to bring in the other stakeholders. So basically for TAFTA, even though of course our primary focus for workplace harassment is to work with the employer, but when we speak with the victims, if we sense that he is very much traumatized or maybe in need of counseling, and then we will encourage him or her to do so, and then we'll provide them with the context for them to make a call to do so. Yeah, and and then we work with NGOs like Aware. So sometimes, I think from statistics and research, we find that actually sometimes the victims are not, somehow they're just not quite comfortable raising it internally to their own bosses or making an official report, but they feel more comfortable talking to an NGO. So we have this collaboration with the NGO here in Singapore, Aware, which championed workplace harassment, and of course, so Aware knows what TAFEP does, so that when these victims go to them, Aware would share with them. Of course, Aware would provide them the counseling, a listening ear, the support that they need. But they would also tell them that there's TAFEP that can help you by approaching your employer, so that the employer can look into it. But Aware, their stance is that they fully respect the individual's decision. They believe in the empowerment of the individual. If the individual is not ready to make a report, then they would just provide emotional support, provide a listening ear, but they will not then refer the case to us. Thank you.
Thank you. So clearly training in handling cases is also important to increase reported cases, making victims feel more comfortable to report. Can I also invite, maybe we go now reverse, starting from Vietnam first. Ms. Hong Dip, you would like to respond to ILO's question, and then I will invite Ms. Wan Laya from Thailand, and last but not least, Dr. Tess from Philippines. Over to you.
Hello, can you hear me?
Yes.
Okay, yes. I have two measures. First, integration. When the complicated and sensitive case, like case of forced labor, child labor, trafficking occur, it will have an integration between state organizations to support each other, like the officer from Ministry of Social Development and Human Security, police officer, and related medical personnel. And two, raising awareness from every section to protect from that case. That's all for my question. Sorry, that's all for my answer.
Thank you, thank you. So you already have a clear referral system in Thailand, which is good to know. How about in the Philippines, Dr. Tess?
Yes, in workplaces, there is a committee that is really that is created to handle these cases, especially on harassment. It's a committee on decorum and investigation, and it is really a committee that looks into harassment, and there are the responsibilities, and like in many countries, we know that it is going to be difficult really for the complaints. It's there is
And once the complaints are out, those who have to handle the cases have to really be sensitized and aware and take the necessary action. So, but if you talk of workplaces, that committee should have the necessary competency and the training. And there are, of course, the experts whom they who can work with them, especially if they have to look into these cases of violence and harassment at work. So, having said that, how do people? We encourage. It's really encouraging them. It's letting them have a voice, so that they can and having people support them. That supportive mechanism is also very important in workplaces. Otherwise, they will just feel lost and they will not report at all. But now that is why in this Safe Spaces Act, it is really the government that it's a whole of society that is increasing that knowledge. It is putting them down so that everybody will understand that they can report there are offensive actions and they have the right to say they're offended. They can call a person out because of the actions done to them by a perpetrator. And that is really what we are developing now. Local governments are doing this. And now for workplaces, we're also intensifying all the efforts. But like I said, if you're looking at workplaces, we do have that committee that has been, that should be created. And our challenge here will be now, of course, for the informal sector, but we're also looking at the possible other committees that can exist, like the Safety and Health Committee, as long as they are, again, well-trained and they can address these complaints. So it's really going to start by letting the people be aware, letting them acknowledge that there is a law and that they have rights.
Thank you so much. You kind of sum up the session. Let me invite Ms. Hongdip, if you have additional comment to share.
Yes, because this is very new with the labor inspection in Vietnam. But if that happens, the victims or the people who was violated, they have a mechanism to report to the political social organization. For example, women union, trade union. So women union and trade union will involved in and help the victim, the worker to report to the authority agencies and help them to recover from all that they got from the action, the violation. So that's all. Thank you.
Thank you so much. And I think after listening to all speakers, the key takeaways that I would like to highlight is basically a combination of 4 key measures in preventing harassment in the workplace. One is having clear legal framework to protect victims. Secondly, having awareness raising, making sure workers are fully aware of their rights. Thirdly, having well-trained officers who are handling cases, so victims also feel comfortable to report. And lastly, having support system or mechanism in the workplace. And so the combination of all these would be an excellent ingredient as we are combating, preventing, addressing cases of gender-based harassment in the workplace. So thank you so much. I learned a lot from all panelists, and also thank you for the excellent questions. I think we are a little bit behind the schedule for this session, but I hope you bear with us. So let me now hand over the microphone to MC and once again give a big round of applause to all panelists. Thank you so much.
Thank you.
Thank you.
Thank you.
Distinguished delegates, we have come to the end of our workshop. And I would like to invite the Secretary General of MOM Republic of Indonesia, as Slom Chair ASEAN, to deliver a closing remarks related to today's workshop, please.
Thank you very much, Honorable ASEAN OSNET Chairs, ASEAN OSNET Focal Points, Honorable ASEAN Labor Inspection Focal Point, Honorable Representative of Asian Partners, Korea and Japan, Representative of International Labour Organization, Representative of International Association of Labor Inspection, Honorable Asian Secretariat, distinguished ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. We had discussed all agendas of all workshops for labor inspectors on violence and harassment in the workplace. It has been a productive and valuable discussion on the workshop, despite it was conducted virtually. I am so happy to meet you all here today. On this occasion, I would like to convey my sincere thanks and appreciation to the ASEAN member states and ASEAN partners for sharing information and initiatives regarding efforts and action on how to improve protection in eliminating violence and harassment at the workplace for the workers. Distinguished participants, ladies and gentlemen, as we are aware that the existence of an unpleasant atmosphere such as violence and harassment will make workers uncomfortable and worried. It can also affect the psychology of the workers and decline the performance of the employee. In responding to these challenges, it needs a strong commitment from the government and related stakeholders, as well as the labor inspectors, to ensure the implementation of regulation and guidance are applied properly. Therefore, let us commit together at this moment to prevent and minimize violence and harassment at the workplace to the workers. Distinguished ladies and gentlemen, before concluding my remarks, I would like to encourage all distinguished participants to further strengthen cooperation under ASEAN OSNET and work together to promote decent work for the workers by eliminating violence and harassment in the workplace. I do hope that this workshop will be followed up by concrete action to create a safe, healthy, and comfortable environment for the workers. Once again, I thank you for your attention and are hard worker. Stay healthy and safe. Hope to see you again in the next opportunity. Wassalamualaikum warahmatullahi wabarakatuh.
On behalf of the committee, I would like to thank for all participants and ASEAN member states. And lastly, I would like to say stay safe for everyone and see you on another event. Thank you.